Welcome back, everyone, from lunch. Hopefully you had an enjoyable time and you'll enjoy being here for the rest of the afternoon. We have some very important topics, and first and foremost is industrial siting. So we'll turn the time over to Director Parfit and Jen.
All right. Thank you, Mr. Chairman. Todd Parfit, Director of the Department of Environmental Quality. And with me is Jenny Staben, the Administrator of the Industrial Siting Council. We were asked to come and provide a status on the local impact assistance payments, the reporting requirements that were passed back in 2022. So I'm going to start off and just give a little bit of oversight background, and then turn it over to Administrator Staben to get into the details of what we found. So just to start off with is that the Industrial Development Information and Siting Act is different than the Environmental Quality Act. It's Title 35, Chapter 12, 101 through 119. The Industrial Siting Act created the Industrial Siting Council, which is comprised of 7 members that serve 6-year terms. They're appointed by the governor and they're confirmed by the Senate. And their role is of the Industrial Siting Council is to issue permits on these industrial siting facilities. These permits. I'm not involved in terms of signing off on those permits. Are strictly through the Industrial Siting Council. The Industrial Siting Act does 2 key things. First, it provides a permit to the applicant after the council considers the social, economic, and natural resource impacts on local governments. And then the second thing it does is it establishes justifiable impact assistance payments for unmitigated impacts to local governments. Now, I just want to give you a sense of what's in, how that impact assistance money is generated and how it's calculated. So the impact assistance payments are not covered in the Industrial Siting Act. They're covered in the sales and use tax statutes, Title 39, Chapters 15 and 16. And then the way the amount of money that's available for impact assistance is determined partly by what the material costs of the project are. So currently, if a project is between the jurisdictional threshold, which is 290 million right now, if it's between 290 and 350 million for material cost, you multiply that by 2.25%. It comes from the state share of the 4% tax. If it's if the project is between 350 million and 850 million, you multiply it by 2%. And then if it's over 850 million, it's multiplied by 1.5%. And just to give you an example of how that would work, so if you had a $350 million project for material costs, you multiply that by 2.25%, what would be available for impact assistance is 7.8 million. If you had a larger project, the mid-size, you just take the high end of that at $850 million project, you'd multiply that by 2%, and there'd be $17 million available to the local communities. And then on the very large projects, which we've had a few in the past, if it's over if it's at $1 billion for material costs, you multiply that by 1.5%, and that would provide 15 million in impact assistance that would be available to local governments. Now, back in 2022, the legislature passed House Bill 47, House Enrolled Act 24. And the reason for that was to show how the money was being spent and to make sure that it was in accordance with the awards made by the Industrial Siting Council. And it was also consistent with the unmitigated impacts defined in 3915-111. So this reporting requirement on the local governments applies to applications where the application was received on or after July 1 of 2022. We've had 13 projects that have been permitted with their application received after July 1, 2022, where the permit was issued. So of those 13, 3 have done their construction, and actually 2 of them have completed construction. One has completed 1 phase and will be starting the 2nd phase. Of those 13, 2 were Trona, 4 were wind projects, 5 were solar, 1 was a gold mine, and 1 was a nuclear facility. The key thing, I think, to convey here is that all the distributions and expenditures have been consistent with the Industrial Siting Council order and the legislation. So that's just a quick overview, and now I'm going to turn it over to Administrator Staben to kind of walk through some of the details.
Please proceed.
Mr. Chairman, thank you. So at this point in time, there's been a total of 13 projects permitted by the Industrial Siting Council, 3 of which have started construction. 2 of those have completed construction. The important part about that is that the disbursement of an impact assistance funds does not begin until construction starts. So at this point in time, of the 13 projects, only 3 have received and dispersed impact assistance funds. So, so I'd like to tell you a little bit about those 3 projects, but before I do, the statute itself states that reporting must begin 1 year after the permit order's been issued. The issue with that is that 1 year after the order's been issued doesn't necessarily mean that construction has started. So while yes, 3 of the projects we have data on where funds have been distributed and expended, the other 9 projects was the collection of reports that just had to report zeros. And because each report has to be submitted by each county that received impact assistance, as well as each town that received impact assistance, it basically came to about 80 reports that we collected of just $0 amounts, while we received 16 reports with the actual dollar amounts. Just so please keep that in mind. Now, to talk about the 3 projects we did that have received impact, or that impact assistance has been dispersed for. The first one is Anticline Wind. That is located in Natrona County. There are 4 towns associated with that. With that disbursement, just so you're aware, the maximum impact assistance available was $3.3 million. Of that, the local governments requested about 60% of that. The council, in that case, did grant that 60% for a maximum impact assistance award of 60% of the total amount of funds available. For Cedars, the next one is Cedar Springs 4. That project is located in both Converse and Natrona County. The maximum impact assistance for that project was $9 million. In that case, the local governments requested about 60% of the total impact assistance available. However, the council awarded 44% of the maximum amount available. The last one was Cheyenne South Solar. That project is located in Laramie County. The maximum impact assistance available was about $3 million. The local governments requested 16% of the maximum impact assistance available, and the council did grant them that 16%. I'd like to step back and explain the process by which the division really evaluated these impact assistance reports. Starting last year in 2024, the division, under the guidance of the council, made a change in some of our procedures. The first change is that historically, because impact assistance and industrial siting permits are determined during a contested case hearing. Part of that procedure is every party to the permit, which would include local governments requesting impact assistance. They have to submit a pre-statement and their exhibits. A pre-statement basically states the law. It lists the witnesses and a couple of sentences of what you expect your witnesses to say, and then a list of the exhibits. What we changed last year in industrial siting under the council's direction is that for local governments who are requesting impact assistance, of course, they still do the pre-statement, state the law, list your witnesses and your exhibits, but they are also now required to do what's called pre-filed testimony. Essentially, everything that all the information that local governments would testify to at a hearing, they now have to write and submit earlier in the process with their exhibits. Now, that testimony can be done as a simple Q&A list, question and answer list. It can be as simple as a letter from the head of your public works, or if they'd like, they could do formal depositions, which is pretty money intensive, so they typically don't choose to do that. Then at the hearing, instead of having a local government come forward with just their exhibits and to at a hearing orally testify the support and the justification of their requests, instead, starting last year, we asked for that justification to be written out beforehand and submitted to the council. The reason for that is that now the council receives those impact assistance requests with the justification for those requests about, I'd say, almost 2 weeks before a hearing. So it gives the council more time to more critically analyze impact assistance requests. Another change we've made as of last year is that as those exhibits are received by the division, both the division and our AG, it sounds very basic, but we literally make a spreadsheet. The spreadsheet itemizes every single request of impact assistance, the dollar amount and what that dollar amount could be used for. We then submit and take that spreadsheet to the actual council hearings. So during the second half of an industrial siting council hearing, that's when you hear the impact assistance. At this point in time and under the direction as a council, like I said, we literally put a spreadsheet up on the wall, and the council and local government comes forward. The council says, does that spreadsheet accurately depict the monetary amount and the purpose or need for that money? Is it, correctly described? The local government can agree, they can disagree, will change it as needed to reflect what their actual request is. And then local government and their officials, their witnesses, stand for questions. Then during deliberations, the Industrial Siting Council goes line by line through that spreadsheet. It is a live spreadsheet, so should the council not award something, change the dollar amount, it happens right then and there in the spreadsheet. Now, this doesn't sound revolutionary, but it is incredibly helpful when it comes to receiving and reviewing the impact assistance reports. So for all of the projects starting last year in 2024, when we receive an impact assistance report, we are able to see the dollar amount dispersed, the dollar amount expended, and what those local governments report those expenditures are. And we can compare it to the exact spreadsheet approved by each local government and the council at the time of the hearing. So we can compare it down to the cent. For projects that are a little bit older, like the 3 I've described today, what my division has done is we go back into the record, we look at each of the exhibits, we read the testimony, and we also review the order or the actual permit to obtain the actual dollar amount requested, the dollar amount awarded, and a description. So that's the procedure by which the division is now evaluating impact assistance reporting to what was awarded. Now, if you don't mind, I'd like to draw your attention to the example impact assistance report that was submitted for your review. This actual form and the format of the report was previously designed with the assistance of both our county commissioners and WAM and input from DEQ. This reporting that we have collected and have analyzed this summer is, I would say, the first round and the first test of our reporting form. The reporting form has what I would call embedded automations, where it was meant to automatically help with addition to the total. Apparently, it also was meant to help with alignment of the descriptions, into the different categories of which impact assistance is awarded. Unfortunately, in the actual implementation of this form, it was brought to my attention that the automated functions and links built into the form do not perform the same on everyone's computer. So if you don't mind, I'd like to walk you through this form and some of the changes that we expect to make. After I received input from the treasurers and clerks in different counties and towns that actually had to use the form, DEQ, we met with WAM and the County Commission Association to discuss ideas. And going forward, we will be changing the form. I'm planning to take out some of its automated features because they proved to not be very helpful. But in going through the form, on the first page, it's very simple: project name, location, who's reporting, and who within that local government is handling the report. On the second page, you'll see that it starts with a reporting period. The first box to be filled out was a reporting period by fiscal year, reporting period also by fiscal year. What was, I think, a little bit of an issue with the reporting is it's not by fiscal year, by statute. It's again 1 year as of the date of the permit order. So the form there just caused a little bit of confusion. As you go down to, it would say impact assistance amount awarded, received, and it would go then to list the different cities. On the county's forms, they list the different cities they've expended funds to. Just to review real quickly, when a project starts, my division then, once we're notified, we notify the Department of Revenue to start releasing impact assistance funds. The Department of Revenue then release those funds in accordance with the schedule of the Industrial Siting Council's permit. And this, basically on page 2, it would say the amount received, the final total distributed. The term final total distributed, I think, was a bit confusing, just simply because folks didn't know if it was the final of that month or the final of that year. On the next page, we have the basic items descriptions, what the quantity was, the total expenditure, and then the total. Then we have, the rest of the form is personnel and position description and the actual position. Essentially, unfortunately, because of the automated features within the form, sometimes the forms would add up numbers that were incorrect. Sometimes they'd add additional decimals. So there were some reports where, quite frankly, in this comment box, the folks that actually had to use the form just copied and pasted a statement of what they spent the money on, the dollar amounts, and that sort of thing. So in the end, every local government that I contacted that I needed to fill out the form did that absolutely as well as they could with the way the form is currently formatted. We will make those improvements. However, everything that they listed as far as a dollar amount and what that was expended on matched the records of both hearing exhibits as well as testimony in the final order of these 3 projects. As far as the reporting of the other 80-some reports of just $0, we did also receive those from the local governments. In closing, I would just like to reiterate that, again, the disbursement of funds and how those funds were used did align with the orders and the orders of the Industrial Siting Council and the requests of the local governments at that time, as decided, of course, with the council. But I do have a couple of suggested improvements. My first one would be if you were to consider improving the statute, it would be to change the language from the reporting to start 1 year after the issuance of the permit. The reason for that is it just creates a number of odd days throughout a calendar year for reporting to occur. One project might be April 12th, one project might be August 4th. And that is a bit cumbersome for local governments to track. My other suggestion would be to create, maybe to go along with that, a standardized deadline, whether it be at the end of a fiscal year for them to submit their reports, or whether it would be at the end of the calendar year. Both of those would be helpful. The other change that I would suggest to the statute, should you consider it, would be to change that reporting should start when funds are dispersed and continue through when funds are fully expended. That way, we wouldn't be tracking, and local governments wouldn't be making reports that are just $0 amounts, because there's nothing to report yet because the funds have not been dispersed. Going forward, the division has plans to improve the reporting. We'll continue to work with the county commissioners and WAM, as well as I've taken in a list and in contacting clerks and treasurers around in different counties and cities who handled this form and have suggestions to be made on it. The division, we will also be more proactive in sending reminders to local governments with deadlines, submission, when their reports are due. And again, my division has put a lot of effort into industrial siting outreach as far as travel to specific towns and counties, making sure our local governments understand industrial siting and how to become a part of it. We've put together a lot of rule and regulation packets as well as information packets. And so with that, we will also be taking with us, basically on the road for trainings, the form to fill out for impact assistance reporting, and just generally become more engaged with our local governments so they understand the process and the expectation. And with that, we stand for questions.
Thank you, Ms. Staben. Appreciate that feedback. Committee, since 2022, this reporting structure has been in place, and unfortunately, the legislature is not in that loop. So that's why I asked for this feedback, to see how that's going, see if it helps with the administration of the impact fees. So appreciate bringing this forward.
Mr. Chairman.
Yes, Senator Cooper.
Thank you, Mr. Chairman. Doctor, when the entities make this application, they have an idea what their construction is going to be. As they go into the project and they find out they have more impact, do they amend this, or is it a whole new process again?
Ms. Staben.
Mr. Chairman, yes, Senator Cooper, that's absolutely correct. My best example of that was just last fall in the Anticline project. The city of Mills realized that they were being impacted by the project transporting aggregate from one part of town to create its concrete on site. And so that was an unanticipated impact of the project. So the town of Mills contacted the division. We then had the council then hosted an amendment to the impact assistance at their quarterly meeting, where they did award the city of Mills a street cleaner. So if a local government is impacted by the construction of the project in an unanticipated way, yes, they can come in front of the council and have their impact assistance amended.
Follow up?
Thank you, Mr. Chairman. Doctor, when if we run into a situation where a municipality and the county are working in conjunction, maybe the facility's in the county, but they're using city water and sewer, if you will, is that still one application, or do both of them need to apply, or is it a joint application, or how does that work?
Dr. Steben?
Mr. Chairman, so by statute, towns can choose to either represent themselves or be represented by the county. So essentially, it's not so much an application, so much as an addition or subtraction of exhibits and pre-filed testimony at the hearing.
Any other questions or comments? Representative Knapp, please.
Thank you. I do like the form, and I do like your suggestions also for improvement, so I appreciate that. My question actually goes to the impact assistance decisions themselves. Is there a standardized pointing system? For instance, one community may ask for a fire truck, another community may ask for walking paths. Is there some regulated pointing system, or are the decisions somewhat arbitrary?
Dr. Steben?
Mr. Chairman, because an industrial siting permit is issued through a contested case proceeding, by statute, local governments have to prove their need and the dollar amount attached to that need by preponderance of the evidence, which means they have to provide a reasonable link between how they're impacted by the project. The council is very aware of what they award a local government. So for example, a town can't request the same fire truck equipment for 2 projects, if that makes sense. A town has to make a unique request for how they believe that specific workforce will impact their community, but they cannot make that same request in the next project, if that makes sense. So that's to avoid what I would colloquially call double dipping. Because the council has to review the actual facts at hand, it being a workforce, it being the distance from the project, and also consider what facilities and what amenities each community has, I would not say it's arbitrary in any way, because they do have to go through all of the facts. During deliberations, they debate a number of facts. But it is up to the local governments, as I do remind local governments, that they have to put together a complete justification that makes sense. Historically, the Industrial Siting Council awards about 40 to 60% of the total amount available. However, last year, that percentage did go up to 68%. The reason for that was because they had Project West, the Trona mine, Dry Creek Trona mine, and then the Kemerer Unit 1 nuclear project. That's 3 big projects with construction workforces over 1,000 coming into those 3 counties in about the same time. And so to make sure, so the counties need to be cognizant of not overlapping what they're requesting, but at the same time, and I guess to put it in a humorous and colloquial way, that part of the state got hammered by 3 projects for that large number of a workforce to come in for all 3. So the council did last year, the total percentage of what they awarded for impact assistance, it did go up a bit, but that was really in consideration of those 3 projects, which I think that's the design of the statute, is for that decision making to be made based on the facts at hand.
Any other questions? Co-Chair Anderson, please.
Mr. Chairman, thank you. We also have impact assistance from the private enterprise that has to come up with whatever they come up with for impact assistance. Can the entity put in for both the impact assistance from the private company and from your office also, and then whichever one comes through, they discontinue the other one?
Dr. Steben?
Mr. Chairman, there is not a specific rule that I can think of that's against that, to be honest with you. The local governments are free to make any agreement they would like with the project. However, the local governments are expected to come forth to inform the council if they, let's say it's a road use maintenance, road maintenance. So if a applicant, if they make an agreement with the applicant that the applicant will cover that type of maintenance, actually, I think we do have a statute against it, don't we? I misspoke. We do have a statute against that. So no, they cannot double dip in that way. I apologize. But we do expect for the applicant to inform the council of when they do make those types of agreements, because it does show that they're being a good neighbor. One thing I know, I've been asked at a local meeting, there was some confusion where in one of the projects, one of the local governments is having difficulty with the project agreeing to a road use agreement. So once the division was made aware of that, we brought that forth to the council, and then the council made it a permit condition for a road use agreement. But that was very separate from the council awarding any impact assistance to the road use agreement. And I think sometimes the public confuses the two. There's a difference between requiring an agreement and the issuance of impact assistance for that.
Thank you.
Any other questions for Dr. Steben? So recently, I've seen one of the methodologies used for impact assistance was increase in population divided by the cost of service. Could you explain that methodology a little bit, Dr. Steben?
Chairman, yes, sir. So in initially looking at cost of service, are the sales and use tax statutes state that unmitigated impacts are for medical services, fire, law enforcement, utilities, and roads. When using the cost of service index or using the cost of service where you take the budget for the year, divide it by the population, and then multiply that number by the number of workers expected to come into the community. Cost of service has been a very easy way to request impact assistance. And admittedly, when I first started looking at it, I was concerned. But the local governments typically, when they break down their cost of service requests, they break down what those services are. So a perfect example would be City of Cheyenne and the South Cheyenne Solar Project. Their breakdown of that was fire, municipal court, support department, street and public infrastructure, planning and development, and police. Typically what is broken down further by the City of Cheyenne, I could read the long list if you would like, but the cost of service is typically focused on fire administration, fire support, fire operations, fire prevention, emergency medical services, municipal court, which arguably would go into law enforcement, traffic engineering, finance, traffic engineering, streets and alleys, city engineering, public infrastructure, and so on. So even in using the total cost of service, I would say of the, let's say 30 services listed, if not 30, then at least 28, 27 of them are fire, medical, roads, utilities, law enforcement.
So if I may summarize this, so let's say a town has a population of 5,000 and they divide the budget for the year by the number of citizens they have, and they say, okay, cost per citizen is X number of dollars per year. And then for the project, there's 100 people coming in for the project. They take that citizen cost per the year and multiply it by the 100 people that are coming in for construction, and that's the mitigation award that they're asking for. So if that's the case, the services that the town has for that year includes the pet center, the senior center, the cemetery. So how does a construction force come in for a construction impact cemetery costs, the cost of a pet center, a senior center? We talk about justification of impacts, but this seems like it's all put into a nebulous area where it's not being justified. It's just saying, okay, cost of service, this is what we're paying for our citizens. So anybody coming in is it's gonna impact our cemeteries. How is that?
Mr. Chairman, the council has on occasion, they will take out some of those dollar amounts, like you said, if it's for pets or the cemetery or something like that, they have in the past on occasion taken those out. So you take the whole dollar amount of the budget, but you would take out that dollar amount for, as you said, the cemetery. Now, by statute, if it is an organization organized under the Joint Powers Act, then the county could ask for it. So that would include maybe an elder center. So the council does look at what those local governments have included in their cost of service.
Okay. All right, any other questions? Seeing none, thank you, Director Parfit. Thank you, Dr. Staben. Now we'll open it up to public comment. Anyone we want to recognize we have an additional legislator here, Representative Campbell. Thank you for attending. Any legislators that would like to provide testimony? Representative Campbell.
Mr. Chairman, committee, thank you. I'm going to just
Please
briefly.
introduce yourself.
Oh, I'm so sorry. Representative Campbell, House District 56. So here in Natrona County, I guess I'm here to strongly suggest that some additional time be spent just on the process distribution of funds as it relates to industrial siting. Have met with multiple municipalities in Natrona County, and there are significant challenges, not only with disbursement. Oftentimes funds are dispersed to the county, and that's at a very late schedule. By the time it goes from the state to the county, from the county to the city, it's years after the project has already been completed. So the question with our municipalities is, the impact is done. It's been years since this project completed, and we still haven't, received disbursement of funds. That's a challenge for many of our municipalities. Secondly, oftentimes because the funds come in after projects and the acquisition of heavy pieces of equipment, our municipalities have to take out loans, and there are fees, and there are interest rates and financing and all of that they now have to carry because the funds distributed from industrial siting don't include any of those things. If they have to do any sort of financing on the front end, those fees, interest rates, all of those, nothing is included. So they end up getting hit with a lot of additional expense. Additional challenges with the process in terms of the contested hearing and time spent and invested and travel. And the serious frustrations our municipalities are running into. So I have information from the municipalities I have met with that I will send to you that kind of details all of those, because I am not a great spokesperson for them. So I will be sending that to you that really lines out here all of the challenges in terms of distribution of funds, financing, and the contested hearing, really creating challenges for our municipalities. So would just suggest, I know this time of year and it being a budget session may not be the best time to rework a lot of this, but would absolutely suggest and appreciate more time spent on this and how the process works.
Thank you, Representative Campbell, and we may recall Dr. State to clarify this, but it's my understanding that we disperse to the counties and then the counties, and we do that on a monthly basis once the construction starts. So is there a disconnect between the counties and the municipalities?
From what I've heard, Mr. Chairman, from what I've heard, both. So there is a monthly disbursement, but sometimes that's 3, 4, 5, 6 months behind.
Dr. Staben, welcome
So
back.
then there's challenges with, this is when the funds should have been distributed, but they're months out from that. So by the time it hits the county, and then by the time it hits the municipality, there's significant time lag between the two.
Ms. Staben? Now you got green. It's,
Oh. Mr. Chair, Mr. Chairman, what I can speak to is my knowledge of how fund disbursement works. What happens is when a project starts construction, it notifies my division. My division then notifies the Department of Revenue that it's time for funds to be distributed. The funds are then distributed on the schedule set by the permit, by the council's permit on their schedule. As far as the delay of that fund disbursement, those funds, as far as a delay in disbursement, I would say is most likely when a project does not start or does not start on the time it stated it would start construction in the permit application. At this point in time, we actually have, I believe, 8 or 9 pending amendments to construction schedules. So there's a number of projects that should have started, let's say, this year, and now they can't start until next year. So the funds for that cannot be dispersed, obviously, until construction starts. The Department of Revenue does control that disbursement of funds to the county. And yes, the county is charged with dispersing the funds then to the municipalities and towns.
so Dr. Staben, once the construction commences, then you authorize it to the Department of Revenue to start making payments. Do you know if there's a time lag between when you notify the Department of Revenue and when that disbursement actually is sent out the door?
So let's say construction started in March, and we notify the Department of Revenue to start disbursements of funds in March because construction has started. Typically, that disbursement, will not start until April.
Okay.
Or
30
towards
days.
the end of April. The reason for that is the concept under the Industrial Siting Act is that the impact assistance payments are based on the state receiving sales and use taxes from the materials for the project. So the Department of Revenue does need to receive some funds from that county that then, let's say they disperse the end of April. However, in that first dispersal, it includes what would have gone out in March and April, and then it's paid basically on a month-to-month per the schedule of the council's order on the permit. I do think, or I've heard especially in the Anticline project, the frustration of not receiving funds for the Anticline project. Going forward, my division can do what it can to make clear that Anticline is a perfect example of a project built in 2 phases. One in 2024, I think their phase ended shortly into 2025, and then the next phase is until 2026. So my office did receive a number of calls on Anticline because I think folks believed they were getting those payments, like the first and second phase were built back to back, but they weren't, so there was this delay in the middle. That's one project I have received complaints on, but they will start construction again in March of next year.
But there's nothing in statute that prevents the county from delaying payment disbursements to the municipalities. They may hold it for a few months, even though the state gives the disbursement to the counties to disperse. There's no statute that says that this has to roll immediately or within a certain time frame to the municipalities.
I believe the statute says that the counties have to disperse the local governments, that's all.
Representative Campbell.
Thank you, Mr. Chairman. I think I understand now why you brought your request, and I understand the frustrations that Representative Campbell's representing as well. But with the ask that you just brought before us here 20 minutes ago to change the language to start 1 year after the permit, to have a standardized deadline, and to have reporting start when the funds are dispersed through, this is the reason why you're requesting this, right? These are the solutions to this problem. Is that what I'm looking at? Would this fix it? Would this help your administration to have time and also get rid of the complaints that, as far as timeliness of payments and stuff? If we were to look at language that would change the language to start 1 year after the permitting, because that affords more time, to have a standardized deadline to where everybody is on the same page where we're at, and to start reporting when the funds are dispersed until it is done. I think that your three answers there would solve this problem, would it not?
Dr. Stephen?
Mr. Chairman, the request to have the reporting occur once funds are dispersed, and then, let's say at the end of every fiscal year that they're dispersed until they're expended. That could serve as a backstop for my division to know if funds haven't been dispersed. That's absolutely true. To be honest with you, my main intention was to put that reporting at a time when local governments are used to doing all of their reporting and accounting at the end of like the fiscal year. And my suggestions, to be honest with you, were initially to more streamline the process so it's easier for our smaller municipalities to meet the deadlines and expectations of the reporting. But to be fair, yes, if a report is due, let's say at the end of a fiscal year and I'm expecting it and I don't receive it, that would inform the division of a lag in the disbursement, it would. Which the division then could bring to the Industrial Siting Council.
Representative Campbell, could you offline get with Dr. Steben and go into this a little bit more detail in the situations that you have, and maybe we can come to a resolution offline?
Absolutely.
And then if there's something that we need to get involved with, bring it forward.
Yeah, absolutely. I think because some of it, thank you for that point, is statute.
Yeah.
Legislatively, we would have to take action on.
We'll start here with my co-chair and then Senator.
Mr. Chairman, Representative Campbell, do we know if this is happening in other counties? I know it's happening in our county, but does it happen in other counties?
Thank you, Mr. Chairman. I can only speak to the, municipalities I've spoken to in our county. So I haven't spoken to any others. So I don't know how to.
Senator Ruffus.
Thank you, Mr. Chairman. Mr. Chairman, I just wanted to raise the fact that during last interim, when we were studying industrial siting a little bit, we had a working group that came together and actually addressed this issue and put together legislation that was drafted last year that the committee didn't end up moving forward. You remember we had about 1,000 different bills, and these ones kind of got left on the table, but I don't think Representative Campbell is aware of it. I know Representative Lawley, Representative Larson, Senator Jones, Dr. Steben were all involved in that conversation. So we actually have a bill draft. I don't think we have time on this committee to raise that bill draft back up, since I believe this is our last committee meeting. But I just offer to Representative Campbell that the draft exists. We put some work in. Dr. Steben was a part of that work last year. And what that legislation did was effectively provide an opportunity to apply for early release of funds when there was specific warrant for those funds. In other words, if you need a new fire engine because you need that up front as the building is taking place, you can justify that ahead of time and get pre-authorization. So, Mr. Chairman, I just wanted to offer that as a solution that's already baked, that could be considered as an individual bill. And I think many of us that worked on it would be happy to co-sponsor that. And I see Representative Larson has his hand up, probably to point out, yes, this is a problem elsewhere.
Representative Larson.
Thank you, Mr. Chairman. Yes, it is a problem elsewhere, and I just wanted to clarify with Dr. Staben. So from what I remember with the conversation last year, you kind of alluded to it in your remarks today, is once the Industrial Siting Council issues an order, it has that schedule in there, and they're equal payments. So in my mind, it's not that the payments are coming late, it's just not enough money's coming up front to satisfy the large expenditures that these communities need to face right off the bat at the start of the project.
Dr. Stevens?
Mr. Chairman, that is correct. No funds are released upfront. They're only released once construction has started.
Okay. Representative Knapp.
Thank you, Mr. Chairman. Representative Campbell, we talk about unintended consequences sometimes, and coming from a district that has had in probably the far past, industrial siting issues, do you think it's wise to really look at sales tax exemptions, for instance, delayed taxes when you're dealing with an area that comes into new industry, to make sure that those are in place, because those are the stopgap measures as well that you receive upfront before your siting money comes in. Would you agree with that?
Representative?
Thank you, Mr. Chairman. Thank you for the question, Representative. I would say I need to learn a lot more, to have an opinion on that, and the impact it has, and the challenges it might create, and how do we mitigate those? Yeah.
All right, thank you for your testimony. Thank you for being here, Representative. Thank you for coming back, Dr. Staben. Any other public testimony? Any other public testimony? Anybody online? All right, with that, we'll close public testimony. Committee, what's your pleasure? Yes, Representative Larson.
Mr. Chairman, I actually would just like to ask if Brian could forward that copy of that legislation we looked at from last year potentially to the committee, just for everyone's perusal if they'd like to look at that.
Okay, so yeah, you could email that. Okay, any other committee comments or directives? Co-Chair Anderson.
Mr. Chairman, I'd like to congratulate the Department of Environmental Quality for the great presentation and clearing this stuff up for us. Thank you.
Yes, yes, and appreciate that. We don't often do feedback, going back and seeing how well our legislation actually, once it's put into place, whether it's working as intended or not. So appreciate that feedback, Director. Okay, we'll move along to the next topic, nuclear facilities, physical security. We have a proposed bill draft. Mr. Fuller, would you introduce that for us, please?
Yes, Mr. Chairman, 26 LS 74, draft 0.5, protection of nuclear reactors. This is 7-01 in the online meeting materials. This is a bill draft the committee requested in May, and is based on language that the TerraPower submitted. This draft would provide an affirmative defense for the use of defensive force, including the use of deadly force in some situations, for the protection or defense of nuclear facilities or employees or assets located in certain portions of those facilities. The draft also would provide detention authority for armed nuclear security guards for persons who are unlawfully at a nuclear facility, and it would create a new criminal offense for trespassing at a commercial nuclear generating facility. So starting on page 4, this creates a new section of statute 62604 in the article of statute that concerns justification for statutes to provide justifications as defenses against criminal prosecutions. The first part of this section are definitions. So beginning with line 9, an armed nuclear security guard is a person who is employed by or contracted with a nuclear power reactor licensed by the Nuclear Regulatory Commission, the NRC, and is located at a commercial generating station, and that guard must also be employed or contracted as part of the security plan that is approved by the NRC and who meets the requirements, the NRC requirements for carrying a firearm. Page 2, line 22, commercial nuclear generating station is a facility that is owned by any person except for the NRC and that produces electricity by means of a nuclear reactor under an NRC license. Commercial nuclear generating station includes the property on which the generating station is located and any other structure and fencing that's associated with the generating station. Page 3, line 9 is the definition of enter. And I'll discuss that more in a minute. And then same with page 3, line 14, a definition of entering or remaining unlawfully. The staff comment on page 4, Mr. Chairman, is just a note for the committee to consider whether definitions of enter or entering or remaining unlawfully are needed for this bill draft. And generally, the Wyoming Supreme Court would take those terms, or any court really, would look at those terms and apply their plain language meaning if they were interpreting these for purposes of, say, a criminal prosecution for trespassing onto a commercial nuclear generating station. One example of this is Wyoming's burglary statute uses the term enter. So one of the elements of that offense is you enter into a dwelling. That term enter is not defined in that section either. So that's just a highlight for the committee to consider. The second part of that staff comment on the top of page 4 is another note for committee consideration, and that would be a consideration for a definition of the term deadly force, which is used in this bill draft but not defined elsewhere in Wyoming self-defense law. That term is defined, and that definition is on page 4, line 20 for the committee's consideration. Then page 4, line 26 is a definition of exclusion area, which is the area of a commercial nuclear generating station where an NRC licensee has the authority to determine all activities, including the exclusion or removal of property and personnel from that area. Page 4, line 33, a definition of protected area, which is the area of a nuclear generating station within the exclusion area that is encompassed by physical barriers. Then finally, page 5, line 2 is a definition of structure and fencing, which is really any structure, fence, yard, wall, building, or other barrier that surrounds a commercial nuclear generating station and posted with signage that trespassing would be a felony offense. The staff comment on page 5 just notes that the language that was provided to the committee at May used the term physical force. Throughout the bill, I have used the term defensive force, which is in line with what Wyoming law currently uses to describe self-defense. The term is defensive force. Similarly, I use the term privileged, which is used in Wyoming law rather than the term justified, which was provided. So page 5, line 27, this is getting into the heart of the bill. So an armed nuclear security guard is privileged to use defensive force against another person at a commercial nuclear generating station if the guard reasonably believes that the defensive force is necessary to prevent or terminate the commission of a burglary, criminal entry, criminal trespass, or a criminal trespass at a commercial nuclear generating station within or upon a protected area. Then page 6, line 6, provides that an armed nuclear security guard is privileged to use defensive force. And here there's a distinction. This use of force can include deadly force if against another person at a commercial nuclear generating station, if the guard reasonably believes that defensive force or deadly force is necessary to first prevent the commission of a manslaughter, murder, aggravated assault, kidnapping, burglary, criminal entry, arson, or robbery within or upon a protected area. Second, prevent acts of radiological sabotage or the theft or diversion of special nuclear material within or upon a protected area. And then third is defend against the use or imminent use of deadly force against the guard or another person within or upon a protected area. Page 7, line 2 provides a privilege for an armed nuclear security guard to threaten the use of either defensive force or deadly force if and to the extent that a reasonable armed nuclear security guard believes that the force would be necessary to protect the guard or others against another person's potential use of force or deadly force within or upon that protected area. Page 7, line 10 provides that an armed nuclear security guard who uses defensive force or deadly force in accordance with this act is not liable civilly or criminally for engaging in that conduct that's privileged. The staff comment on the bottom of page 7 and page 8 just notes slightly more condensed language that was used in another act that the legislature enacted in the 2025 session concerning the use of force for protecting military equipment. And that's just there for the committee's consideration and discussion. Page 8, line 9 allows an armed nuclear security guard acting upon reasonable belief to detain a person in or at a commercial nuclear generating station in a responsible manner and for a reasonable time if the person is suspected of committing or is attempting to commit any of the offenses that I described previously in the bill draft for purposes of summoning law enforcement. Then an armed nuclear security guard's reasonable belief to detain a person is an affirmative defense in any civil or criminal action against the guard, the employer, or the owner of the commercial nuclear generating station where the guard was employed for false arrest, false imprisonment, unlawful imprisonment, or unlawful detention. The staff comment on page 9 just notes different language that the committee may wish to consider that is already used for those owning retail establishments and their ability to detain and interrogate a person suspected of theft. And the committee may wish to consider using language like that as a model in lieu of the previous 2 subsections on page 8, lines 9 through 25. Then page 9, line 35, this is a new section of statute that would create the new offense of criminal trespass at a commercial nuclear generating station. The definitions that I previously went through would apply in this section as well. That's on page 9, line 38. Then moving on to page 10, line 2, a person is guilty of a criminal trespass at a commercial nuclear generating station if the person knowingly first either enters or remains unlawfully in or on a commercial nuclear generating station, or second, enters or remains unlawfully within the structure and fencing of a commercial nuclear generating station. This new offense would be a felony punishable by imprisonment for up to 5 years, a fine up to $1,000, or both. The staff comment on the bottom of page 10 and the top of page, most of page 11, just notes 2 sections of statute that the committee may wish to consider whether those sections need amending. 61204 at the top of page 11 concerns immunity from civil action for justifiable use of force, and whether a reference, particularly in subsections B and C, are needed to reference the new section created in this bill. 62504, similarly, this would be subsection B, whether a statutory reference is needed in the offense of reckless endangering to exclude the conduct that's authorized in this bill draft. This would be effective July 1st, 2026. Mr. Chairman, happy to answer questions.
Thank you, Mr. Fuller. Committee? Senate Majority Floor Leader.
Senator, another comment. Thank you, Mr. Chairman. Just a question for Ella. So the original source of this bill draft, was that LSO generated, or were there or was a proposal provided to LSO staff? The reason why I ask, and one of my questions about the bill draft in these conversations, is I'm surprised at the rewriting of so much of our criminal code into this new niche provision, and I have deep concerns about that, as have been noted by LSO staff. So just a question about the sourcing of this draft.
Mr. Fuller?
Yep, Mr. Chairman, Senator Nethercott, this language was provided to the committee at the May meeting, and if I recall, I believe the testimony was this was based on the law of another state. I think perhaps Arizona comes to mind.
Follow-up, Senator?
Yeah, Mr. Chairman. Although it's always easy to grab from another state's laws, it creates a lot of inconsistencies and will invite, I think, a lot of challenges for the employee, the armed nuclear security guard, who is needing to avail themselves of what this law is intending to protect, will actually do the exact opposite because of the inconsistent nature of how it plays in with the entire criminal code. So if someone is needing to avail themselves of this law, there's a serious issue that's occurred, including a potential homicide. And so you don't want to create ambiguity associated with that type of defense. And so, Mr. Chairman, when we get to the time of discussion, I intend to make a motion, just kind of alerting the committee to adopt most of LSO's recommendations and to start maybe having it sit more comfortably with the nuclear energy companies whom I support this effort. I just want to make that clear. You have these protections already in statute. Everyone in Wyoming generally does. And I know you want it carved out uniquely, and I think that's important to have some carve-outs unique to the industry, so it's very clear. But I don't know if it needs to be this explicit and explicitly different from our current criminal code. Thank you, Mr. Chairman.
Thank you, Senator. Appreciate the comments. Any other comments? Thank you, Mr. Fuller. Appreciate the recap of that proposed legislation. We will now hear from Andrew Richards, Vice President of Government Affairs, TerraPower. Looks like the whole slew of them. He has lots of friends.
Yes, he does.
So whoever wants to start, please introduce yourself and proceed.
Thank you, Mr. Chairman. My name is Travis McNevin, here on behalf of TerraPower. Of course, with me, quick introduction, as you stated, Andrew Richards, Melissa Darlington, and Martin Fredo. They will each address you and introduce themselves further. We certainly appreciate the committee's time and LSO's efforts in bringing forward the protection of nuclear reactors, LSO 0074.5, and appreciate the committee's consideration and hope they'll be able to advance this bill, this topic, of course, for the upcoming session. And so with that, Mr. Chairman, if it's all right, may I turn it over to Mr. Richards for opening comments.
Please proceed.
Thank you. Chairman Anderson, Chairman Heiner, and members of the committee, thank you for the opportunity to appear before you again today. My name is Andrew Richards, the Vice President of Government Affairs for TerraPower. I'm here on behalf of TerraPower alongside Melissa Darlington, TerraPower's Nuclear Security Manager, who just moved to Kemmerer, and Martin Fredo, who leads TerraPower's Nuclear Physical Security Program. We are grateful for the chance to continue working with you and the Legislative Service Office on the important topic of nuclear facility security. We're here to express our support for the security legislation under discussion today. TerraPower deeply appreciates the diligence and thoughtfulness with which this committee has approached the development of this security legislation. We would also like to thank the Legislative Service Office for their careful drafting of the security bill and their efforts to ensure the proposed statutory language fits well within Wyoming's legal framework. As you know, TerraPower is actively constructing our Natrium reactor in Kemmerer near the Naughton Power Plant. Natrium is an advanced nuclear energy facility designed to deliver safe, reliable, and baseload electricity. The project represents a major public-private partnership with the Trump administration and is poised to bring long-term investment and economic development to Kemmerer and to Wyoming. Since we were last before you, several major milestones have taken place. First, President Trump issued several executive orders aimed at promoting and supporting civil nuclear energy in the United States. Further, the Trump administration has subsequently reaffirmed its commitment to our public-private partnership, and the House of Representatives has also signaled continued robust support for the project. At the site in Kemmerer, construction is progressing steadily. We recently finished laying the foundation for the test and fill facility and are about to begin construction on the Kemmerer Training Center. Construction on the Energy Island, which is the largest portion of the facility, will begin in a few months. Lastly, the Nuclear Regulatory Commission announced that it has accelerated the timeline for reviewing our construction permit application by several months. As we progress through licensing and construction and ultimately transition to operations later this decade, the safety and security of the facility, its personnel, and the community will remain a top priority. The legislation under consideration today provides essential legal clarity and protection for the security personnel who will protect Wyoming's first advanced nuclear reactor. It does so by affirming the authority of licensed armed security personnel to use defensive force within protected areas of the site in accordance with NRC requirements. It provides security personnel with the ability to reasonably detain individuals suspected of unlawful activity for the purpose of summoning law enforcement, and it establishes civil and criminal immunity for security personnel acting in good faith and within the scope of their NRC-approved duties. We fully support these provisions. NRC-licensed nuclear facilities, like Natrium, are federally required to implement robust security programs, including the use of force to deter and defend against threats such as radiological sabotage. However, without this legislation, Wyoming lacks the state-level legal framework to protect the individuals charged with carrying them out. We also appreciate that the bill aligns its terminology with existing Wyoming law, using terms like privileged and defensive force to ensure consistency with the state's self-defense statutes. Importantly, the authority to use deadly force is appropriately limited to the reactor's NRC-defined exclusion area, a key safeguard that helps ensure the safety of the facility while maintaining a responsible and balanced approach to security. We would, however, like to highlight a potential issue with Staff Comment 3, which suggests modeling the use of force provisions on an existing statute related to the protection of military equipment. Because there is no published NRC doctrine similar to military regulations, using the structure of the military statute would create ambiguity and likely require the bill to be substantially rewritten. We respectfully recommend the committee retain the current language, which appropriately reflects the unique regulatory and operational environment governing nuclear security. In closing, we want to reiterate our gratitude to the committee, LSO, and the broader Wyoming community for your leadership and engagement on this bill. Wyoming has been a committed and forward-looking partner in this project, and we are honored to be working with you all to advance the next generation of nuclear energy. TerraPower is committed to being part of KEMR and Wyoming for the long haul and contributing to the state's economic development and energy leadership. Thank you for your time and consideration. We have provided a handout with our individual response to each LSO staff comment, and Melissa, Martin, Travis, and I are happy to answer any questions that you may have. Thank you.
Thank you, Mr. Richards. Travis, anyone else you want to add?
At this time, Mr. Chairman, we would simply take any questions or seek to answer any questions. As was noted, we also provided the committee with a handout of each of our thoughts on the staff recommendations, in summary, which we concur with all of them, minus maybe the military language staff comment, but felt like all of the other staff comments certainly enhanced the bill. And happy to go through them individually or just take questions at your pleasure, Mr. Chairman.
Okay, thank you. Representative Campbell, please, go ahead.
Thank you, guys. Thank you, Mr. Chairman, and thank you guys for being here today. I'm curious, and I was going to ask you guys this last time that you were down here and I didn't have the opportunity. Is there any special considerations with these SMRs that are not applicable to a full-size nuclear power plant? Is there anything above and beyond? Is there any special concerns that warrant any extra security, I guess?
Ms. Darlington. There you go.
Thank you, Melissa Darlington, Mr. Chairman. No, actually, and this is my opinion, we are having the same security level as a full-size nuclear reactor, and in my mind, they're a lot safer, but we are still meeting all the nuclear requirements for a light water reactor. Thank you.
Follow up? Okay. Any other questions from the committee? Senator Nethercott.
Thanks, Mr. Chairman. Excuse me. On page 11, line 17 through 23, and this whole section really for immunity from civil action. This is currently in our statutes, which is pretty extreme for how you can be protected from a charge of wrongful death or homicide. But this is in contemplation of an individual like, defending their home or their property or their self in any location. This isn't in regards to an employee of a company acting in their scope of employment. And so I am curious if within your policies you will provide some type of indemnity to your employee who is privileged to use the type of force contemplated in this bill, as opposed to potentially TerraPower being awarded attorney fees from a suspect's family or an individual's family who was shot and killed entering the premises? If you've thought that through.
Mr. Chairman, my name is Martin Fredo. To answer your question, Senator, I think really what we're looking at is we're looking at individual responsibility. And when we talk about a security officer, we're really looking at providing them some level of protection. When we look at how we train security officers, there's a term we use of force continuum. And I think it'd be helpful for me to discuss that a little bit, just to give a little background on how a security officer comes to a decision on when they're allowed to use force up to deadly force. And so in the Nuclear Regulatory Commission, we have a training and qualification program, which is a plan that has to be approved by the Nuclear Regulatory Commission along with several other plans. And within that plan, it talks about a use of force continuum. And for those who may not be familiar with it, generally, I'll start off with officer presence, uniform. Think of a police officer. You see a uniform, you know, they have a position of command. Then you have verbal authority, and then you begin to escalate. And as you escalate through different levels of force, be it with chemical agents, be it deadly force, the security officer is left with a position of having to make a decision at that point if they're authorized to use it. And so really what the whole objective of this discussion is to make it very clear to the individuals that they are permitted to use force, because there's a lot of ambiguity as far as when you start applying these levels. And I'll just take it one step level. And really what we're talking about when we talk about deadly force, there's four conditions that have to be met for them to use deadly force. They have to see an adversary prevents the ability to create havoc, radiological sabotage, for example. They also have to have the opportunity to do it. They have to have imminent jeopardy. That means the security officer has to feel he's in jeopardy, imminent jeopardy, and there's also preclusion, which means that the individual has no other recourse but to do this. And so to get to your point, you know, I know it's a roundabout way, is at some point, somebody's going to challenge the security officer if there's an instance where a deadly force is applied. They're going to say, okay, explain to us why you did this. And there's always somebody in the legal world who will come back and say, okay, so why did you feel you were in imminent jeopardy? Many of our security officers are located in ballistic hardened guard towers. So somebody may come along and say, you weren't in imminent jeopardy because you were protected from a bullet. And see, these are the types of scenarios that create uncertainty for security officers. And then what subsequently happens is, this has never happened, obviously, in the US where a site's been attacked. But if somebody does attack and this person pauses because they know somebody's going to challenge them and say, well, for a preclusion, I just shut the door, I'm no longer a threat, why can I continue to shoot? And so this is really what we're getting at. Did you want to share something?
Ms. Darlington.
It looked
Yes,
like you did.
I did.
I can also ask the question in a different way, which I think may be
I
helpful.
know what you're asking. Oh,
Let me ask the
Mr.
question a different way if I can.
Yes,
Mr.
Senator,
Chairman.
please.
Does the company TerraPower want immunity from one of these actions? Because you don't currently have it in the bill draft. Your employee would, but TerraPower would be the one sued. So does the company want immunity or not?
I understand the question. I'm going to speak to our legal counsel to get you an answer.
Go ahead, Mr. Richards.
Excellent answer.
Okay. Any other questions? All right, seeing none, thank you very much.
Thank you.
We'll now open it up to public testimony. Is there anyone in the room? We have one in the back. Please come forward. Welcome.
Go ahead.
We'll start with ladies first, if it's okay.
Absolutely.
Please introduce yourself and proceed.
Hope Dennis from Buffalo. And the reason I'm here, after reading 26 LSO 0074, protection of nuclear reactors in Wyoming, I became concerned about the lack of a rounded security plan. This bill only covers security for security personnel, and their ability to react to different situations. To me, there seems like there's far more aspects to security that are not mentioned, such as drones, microprocessors made in China, earthquakes, faults, and human errors.
Can you pull that microphone a little closer there? Some of these guys can't hear.
Oh, I'm sorry. Is that better? Okay. The first one, drones. Airports and military bases have reported an increase of drones in their airspace. With the increased use of drones to attack nuclear and military facilities, we should be concerned about our infrastructure. In an article by Andrew Thorbrook in Epic Times, June 19th and 24th, 2025, he talks about the drone attacks after Ukraine launched a surprise attack on Russia earlier in June, and Israel suspected of using the same strategy against Iran. And Israel smuggled drone parts into Iran, assembled them, then used them to cripple their military planes. That's a scenario that could easily take place in the US. Mr. Thornbrook reports that the US military leaders are increasingly concerned that similar attacks, which leverage low-cost commercial drones against expensive weapon systems, and it can pose a lasting threat to bases and critical infrastructure throughout the country. However, the Army and other service branches are struggling to design and deploy appropriate technologies to defend bases on US soil. Mr. Thornbrook brings up another issue in dealing with drones on US soil versus drones on US military bases in foreign countries. Quote, whereas officers at an outpost overseas might simply engage with an unidentified approaching drone to their base before any potential harm can occur, the military lacks the ability to engage with drones on US soil unless those drones enter a facility in their airspace, which is sometime maybe too late. What will Wyoming's costs be to support and maintain a counter-drone system for the security of nuclear power plants and the smaller nuclear modules? What will be the liability for Wyoming? And is there a plan to drone-proof nuclear facilities? The results of a drone attack on a nuclear facility could result in a nuclear catastrophe for generations. The next security concern is American designed microprocessors built by China or by the Chinese. Research scientists with Cambridge University discovered backdoors built into the microprocessors that can be used in military weapons, nuclear power facilities, and transportation systems. And they suspect that's already happened. Richard Dudley of the Defense Update writes that the built-in backdoor that can be reprogrammed, and the built-in backdoor, according to the Cambridge scientist, cannot be fixed, and the only remedy is to replace the chip itself. My question is, do we know what processors will be used at the Kimmer plant and what processors will be placed in the small modulars? The next concern I have is human error. Another type of security issue that is not addressed in the 26 LSO 0074. Human error was one of the factors in the disaster in Japan. If the Kimmer plant is experimental, how many human errors will it take to get it right? And can we trust human error with the experimental small modulars in our communities? The next concern is earthquakes possess a security risk. In Lincoln County, where the Kimmer plant is to be built, there were 8 earthquakes above 5 magnitudes since 1970, according to the Wyoming State Geology Survey. And there was one of 3.9 only 2 weeks ago. Faults are another issue, and according to the Wyoming State Geological Survey, the Kimmer plant is right by the Rock Creek Fault. And I do have, this is from the Geological Survey, if anybody's interested, and it shows the fault lines that are in Wyoming and the location to Kimmer. And there's a lot more earthquakes happen than people realize, especially in that part of the state. Any questions?
Are there any questions? Senator Cooper, please.
Thank you, ma'am. Thank you, Mr. Chairman. Ma'am, you presented a lot of information here, but very little of it had to do with the bill. Do you have any specific concerns about defense forces? Nothing to do with earthquakes or any of that. This bill concerns defense force for protection of these of the facilities.
And I think that's just a fraction of what the security needs.
Doesn't matter, ma'am. That's what the bill's about. Do you have any further comments on that?
I do. There's, as far as, are they depending on the TerraPower supplying and training the forces? Are they going through military training? Are they going through police training? Or do they have, and hazmat would be another thing kind of tied into that too. How would they react to an emergency at the plant?
Representative Larson.
Thank you, Mr. Chairman, and thank you for being here. Did you, by chance, watch our last committee meeting in May on the nuclear security? We had a presentation from the Nuclear Regulatory Commission, and they provided some resources and a packet on that.
No, I did not. I'm sorry.
No, it's all right. I just wanted to let you know that that's available on our website. There's a lot of resources there. And what this bill contemplates is on page 2, it says they're employed or contracted as part of the security plan approved by the USNRC. So the USNRC kind of has a whole set of guidelines and that all of these facilities have to meet for their security plan. And there's a lot more resources online about that as well. So I just wanted to make you aware of that.
Okay, thank you.
Any other comments or questions? Thank you very much for attending. Sir?
Good afternoon, Mr. Chairman, committee members. My name is Ken Hume, and I live in Bar None. I apologize for the address. I hadn't planned on addressing you guys today. That would come tomorrow. But something that bothered me when, just in the previous discussion, the term nuclear generating facility was used over and over. And I feel that that needs to be changed in the bill to say something like nuclear facility, looking specifically at Radiant that's going in north of us, north of Bar None. I live in Bar None. And they are not a nuclear generating facility. They will not generate any nuclear power there. And I think the Wyoming statutes and laws need to be the same whether you're running a full-blown reactor in Kimmer or whether you're doing the manufacturing and shipping out in Bar None.
Thank you. Any comments or questions? Senator Nethercott, please.
Mr. Chairman, thank you. I think the gentleman makes an excellent point. Just for clarification to LSO, do you see that distinction in the bill draft, as the gentleman has pointed out? Does the privilege apply to all nuclear facilities or just nuclear generating facilities?
Yeah, Mr. Chairman, Senator Nethercott, it is a facility that produces electricity. So it would be really nuclear reactors generating electricity that are covered under this bill. It would not include any facility that manufactures reactors or stores spent fuel on site, Mr. Chairman.
Thank you.
Okay, and just the last comment on that, you guys need to change that.
Thank you. Thank you.
Or come up with another bill for that, just specifically for this purpose.
Thank you, Mr. Hume.
Thank you.
Further comment, further public testimony. Ms. McCain?
Good afternoon, Chairman. My name is Sharon Buccino, and I'm serving as the Executive Director of the Powder River Basin Resource Council. And with me today is Nancy McCann, who may assist me during this testimony. Powder River's membership consists of about 1,500 folks, many of whom reside in the Powder River Basin, which holds a critical supply of many of the state's energy resources. Many of our members recognize the importance of energy diversification and the economic opportunities that come with it. Nuclear energy can play a key part of such diversification. Some of our members also live in communities that would be directly affected by the manufacture and subsequent refueling of small nuclear reactors to be transported and used elsewhere. Security is a critical issue, and Powder River supports efforts to protect nuclear material wherever it may exist in the states. So we do support the comment and the recommendation just made by the resident of Bar None that the scope of this bill be expanded to cover nuclear material wherever it might exist in the state and not be narrowly limited to the definition of commercial generating facility. Yet, security is only one issue that must be addressed before Wyoming communities can be comfortable with nuclear energy use nearby. And so do welcome the opportunity to discuss those issues further tomorrow morning. I'd just like to make one point, though, at this point, which is the importance of education and empowerment of our members, Powder River's members, but also the citizens and residents of Wyoming, that this is key to providing a voice in decisions that will impact their environment and lifestyle. And essential to that effective yet efficient community engagement is giving residents trustworthy information about key issues in a say in the decisions that affect them. So that's the Wyoming way, but it's also the way to get to yes rather than just no. And I know that personally from my role as a commissioner on the City of Laramie's Planning Commission. And so we see, and you've seen it as well, that when a home or a business owner comes before us requesting a variance from the zoning requirements, they may walk away not agreeing with the decision that we made, say if we deny that request, but it makes a huge difference to them that they feel like they were heard and that we understood the concerns that they are bringing. So I commend you for the efforts to take and hear public testimony, but the testimony and the engagement in communities that are directly affected by these facilities is critically important. And just this week, actually, that kind of engagement is happening. The University of Wyoming is helping with that community engagement out in Kemmerer right now. TerraPower has been participating, but that view is only one view, and having these credible sources of information is critically important. And I very much appreciate the opportunity to testify, and I'm happy to answer questions. I would just like to highlight a written testimony that was submitted earlier today by Ron Smith, the resident of Powell, Wyoming. He submitted that testimony on his own behalf as an individual resident of Wyoming, but he has some of this very valuable expertise in terms of having a degree in engineering physics from the Colorado School of Mines, as well as an MBA from the University of Wyoming, and 40 years consulting to mining and power generation industries, including the Nuclear Regulatory Commission. He provided helpful testimony, I think, to the committee in the last session, and is the kind of information that I think is important before rather than after the legislature authorizes the storage of nuclear waste, including spent fuel. Thank you.
Thank you very much. Ms. McCann.
This is Nancy McCann. Thank you, Chairman and committee. The one thing I would like to add with regard to the bill, when I viewed this bill, I think of it as an on-the-ground bill, so on-site, on the ground. I never thought of it as being in the air. However, there are some things that couldn't happen in the air, and so any kind of clarification that could be made, I don't have any that I can provide, but after talking to Travis McNiven with TerraPower, I said, well, what is being done if there was some sort of error attack? And the question and the answer would be, well, is the FAA involved? So maybe further clarification in this bill, if it's a non-on-the-ground attack, might be something that you might consider. And as Sharon noted, having the bill be expanded to more than just the commercial electricity generation facility to anything nuclear. And the reason I bring that up, and I'll just tell you a little story about my dad. My dad used to take all the airmen out to all the different missile sites, and you had to have security clearance to get out there. And so with the $190 billion efforts that the Air Force is doing, and they're improving all the missile silos, that there is security out there at all missile silos. And so if there's security there for those missiles, then anything nuclear, whether it's TerraPower, whether it's in manufacturing, if you have any nuclear residue or spent fuel or whatever, you really should consider either having a new bill or expanding this to include. And so, and with regard to the training and certifications of the guards, I questioned, because there's so many moving parts at the federal level, so many moving parts at the state level and county level. I wondered if TerraPower could be brought back to clarify, are the security guards federal employees, or are they employees of TerraPower, or who are they specifically? And I know that there was a previous meeting on minerals, but I did not get to see the full scope of that. There are NRC clearances and training and certification that all these guards would need to have, and we need to make sure that there's standards. And how does that fit in with Homeland Security and the local efforts. So these are questions that I had in my mind, and I wanted to bring it to the committee's attention, because there may be answers out there. I just don't know what they are yet. And so I stand for any questions, and thank you.
Thank you, Ms. McCann. Any questions? Senator Nethercott.
Yeah, Mr. Chairman, thank you. I think when it relates to the narrow scope of this bill draft, which is really authorizing the security guards for a nuclear facility to use lethal force when justified, that's the purpose of the bill. And that concept, despite its uniqueness in Wyoming as it relates to nuclear, as I mentioned before, isn't entirely necessary because our law already affords those types of protections really for all things. But it's not dissimilar to a bank security guard and how they might interface with the FBI, because bank robberies are federal jurisdiction, it's with federal agents, but that doesn't preclude potentially a bank to have a hired armed security guard to take appropriate measures if the bank were to be robbed, and then work in concert with the federal agency concerning that action. So I don't think this is a new concept per se. Its application to a nuclear facility is, but I think those same arrangements would be in place here. So I personally don't see the bill as being that particularly unique or special. I think TerraPower and those nuclear facilities just want that extra certainty associated with the uniqueness, the harm that comes from a bank robbery versus the harm that comes from attacking critical infrastructure is profoundly different to the public. And so they want that extra certainty. But it's not dissimilar potentially to an armed security guard in a bank.
Yeah, and I think you make a very good point. Just drawing on my experience having taught legislation at the University of Wyoming's Law School, along with LSO and Brian Fuller, good to see you. I think the point about being careful not to duplicate what already exists is an important one. And when you put some specificity out there, then you're opening the door to what might be argued is excluded because it wasn't included. So I think that's just something that's worth considering. There's not an easy, straightforward answer, but I think that's an important factor.
Okay, any other questions? Seeing none, thank you very much for your testimony. Any other public testimony?
Good afternoon, Chairman and Co-Chairman and members
Could
of...
you pull that mic a little bit closer, please?
It's on. Can you hear me?
You just pull it a little closer.
Okay, thank you. Good afternoon, Chairman and Co-Chairman and other members of the committee. I'm kind of picking up and read this, but I'm kind of freelancing a little bit on this particular subject.
Could you please introduce yourself?
My name is Kathy Klein. I'm a citizen of Sheridan County, but I also have 35 years in intermodal transportation and rail. And I do agree a lot with what Senator Nethercutt had made, that a lot of the similarities, I appreciate your comment on that. But this is not an home entry type. I have been on a nuclear facility compound in Hanford in transportation. I feel a lot of what you're saying is actually correct, and I agree that we are in that particular situation. But on this particular bill, I feel that we should be addressing more, and like the other lady said, in other aspects, to have it all under one and not so vague, only to fit one particular person. It should, if we are bringing nuclear energy here, we should be in all around nuclear energy for one bill, in my opinion. And it would be under the NRC. I do understand the security, but I believe it should be more militarized. If it is for like a larger nuclear, and these SLRs are the same, then I think we should be having the same militarized bill for security and not so light and lackadaisical, because we're going to be moving rail, air, and truck and refueling. So if it is like a bank robbery, we're more susceptible to some type of a invasion or robbery, especially on the highways. I know what the highways are like. So my concern is just adding a little actual more militarized. Then I understand the NRC. I did watch it. I know what their rules are, and I know the training those officers go through. But for me, this is more, and no offense to anybody, this is more Pinkerton style for a nuclear. And I feel that we should be more militarized if you're calling about more lethal weapons for security. They are trained for all scenarios, sir. I do understand that, Senator or Representative Larson. I did read it. I just have a little bit more concern that it should be entitled to more types of transporting in our fuels. So that was just my opinion. Thank you.
Thank you, Ms. Klein. Appreciate your comments. Any questions? Thank you very much for your.
Thank you.
Any other public testimony? Anyone online? Seeing no further testimony, we will close public comment. Committee, what's your pleasure?
Move the bill.
Move the bill by Co-Chair Anderson, seconded by Representative Larson. Let's go through the bill page by page. This is one that we might have a few comments about. So page number 1, any comments on page number 1? Yes, Senator Rothfuss.
Thank you, Mr. Chairman. We haven't talked about it much today, a little bit, but talked about it last time. Looking at the definition of armed nuclear security guard, it provides some requirements. And one thing we discussed previously was the idea of what qualifications we want them held to. And post-certification in the state of Wyoming would be a qualification that we could very easily add to ensure that any individual is post-certified and appropriately certified within the state of Wyoming. To me, that seems like a reasonable minimum. It doesn't necessarily go as far as some of the advocates suggested. So I think, and again, we're sort of expediting our working of this bill, but I think amending a C paragraph in that requires that any eligible armed nuclear security guard be post-certified within the state of Wyoming is a reasonable minimum threshold. So I would make a motion to add a C paragraph that they be post-certified and provide flexibility to staff to use appropriate statutory language consistent with our other statutes on how we would structure that post-certification.
And Senator, is that on which page are we?
I'm sorry, you said page 1. I was looking at what is effectively the first meaningful page, which is page 2. My apologies, it's on page 2.
Okay, on page 2. Let's jump to page 2.
Yeah. On page 2, Mr. Chairman, what I said.
I misheard you, I'm sorry. Okay, so the motion is paragraph C.
Yeah, under Romanet 1, for the definition of armed nuclear security guard, it's a series of and provisions, so you have to meet each of those to achieve the definition of armed nuclear security guard, and adding post-certification as a requirement.
This would be on line 21 of page 2.
That is correct.
Okay.
Paragraph C.
Paragraph C.
It would be a new paragraph C. Page 2, line 21, we would be inserting a new paragraph C under the definition with language that would indicate a requirement for post-certification.
And he has that verbiage that he's going to give to.
Second for purposes of discussion.
Okay, second. Any discussion on this? And the verbiage you will have more for the LSO?
Yeah.
Right.
Yeah, Mr. Chairman, I think the language would be pretty straightforward. You just say, who is certified by the Peace Officer Standards and Trainings Commission. Mr. Chairman, the two additional notes I would offer. First, there may be a need for additional conforming amendments in the post statutes to contemplate the commission to certify these individuals as being certified. I believe right now the statutes generally refer to peace officers, correctional officers, and dispatchers as being within their duty to certify. So that would be the first point I would note. The second point I would note, and I've tried to do some looking very quickly. I don't know how this requirement may comport with the NRC's requirements under federal law for how those, the requirements for those personnel to carry firearms there. I know there's at least one federal regulation that applies to those persons. And I don't know if post-certification would conflict with any of that, but just wanted to put that on the committee's radar.
Thank you, Mr. Fuller. Senator Ross, please.
Yeah, quick thoughts on that. I would say certainly for the latter with the NRC requirements, it would be cumulative. You would have to meet post-certification and you would have to meet any NRC requirements, or pursuant to the A and B paragraphs, you wouldn't make the grade. So I think that's going to work itself out. As far as other conforming language, if there's a need for that, I think it's appropriate to conform. But it was my understanding you effectively can be post-certified without necessarily having a position if we need to expand the language in statute for what somebody can be applying for post-certification for. I think that would be reasonable, but I think that's still, again, consistent. We're not creating any new requirements or any burdens on post, I think, with that provision.
Senator Nethercott.
Yeah, Mr. Chairman, thank you. As we discuss this proposal, it seems simple enough. I believe the rationale for the motion is to ensure that the armed security guards are properly trained and have some type of oversight concerning their abilities. I think that makes sense because I'm not aware of any other occupation or individuals in the state that are allowed to have these powers while being armed, although again, all Wyoming citizens do, but that's a whole different topic. But some concerns to think about when you speak to your legal, which is additional exposure as a result of potentially being a peace officer, because the immunities being provided to citizens and security guards aren't the same immunities we give to police officers. In fact, we try to take those away in Wyoming, or at least we have in certain recent years. So there's some concerns there, I think, of additional liability exposure that we're trying to avoid here. We're really carving out this unique exception for armed nuclear security guards that we don't also provide to our law enforcement officers. And so that may create a unique class that I don't support the policy of, but I think those are conversations we need to have. So just something to think about, and maybe I'm looking at the Association of Sheriffs and Chiefs there, and maybe in session or at another meeting, we can potentially hear from Post concerning that particular concept. So nothing further, Mr. Chairman. Thank you.
Thank you, Senator. Any other discussion? We have a proposed amendment on the table, and it's been seconded. Any other discussion? All those in favor of Senator Rothfuss's amendment on page 2 signify by saying aye. Aye. Any opposed by the same sign? All right, that amendment has passed. Any other changes on page 2? Senator Rothfuss.
This is where we'd want to make the amendment, I believe, at the bottom on page 2, line 22, changing it from commercial nuclear generating station to commercial nuclear facility would be my suggestion, and then conform throughout statute, come up with a new definition. And I would suggest at this time, again, we're winging it just a little bit since we aren't taking this over to the next meeting, that the NRC needs to require, as part of the license, that you have a security plan where you need lethal force. So something along those lines would be a reasonable threshold. In other words, you're not a facility that's operating an X-ray machine that is a registered nuclear facility. And all of a sudden your security has this same waiver, right? We need the NRC to be making a requirement for this type of security plan, and then that raises to our commercial nuclear facility. And again, provide staff with the flexibility, but coming up with a new definition, conforming throughout so that we're talking about a commercial nuclear facility, and then setting a standard based on the NRC. That's the motion.
Okay. Do I have a second?
Mr. Chairman, I'll second it, but I think we got a change it in certain other areas in the bill too.
Yeah, you'll have to be conforming throughout the bill.
Yeah.
Yeah, conforming throughout, that's what I meant.
So this,
It's a big
so
change.
we have a proposed amendment on line 22 of page 2, commercial nuclear generating station to be changed to commercial nuclear facility. Is that correct? And conforming throughout the,
Yep. And Mr. Chairman, just to be clear, Senator Rothfuss, what I'm taking away is this would apply to commercial nuclear facilities that are required to be licensed by the Nuclear Regulatory Commission and that are required to have a security plan as part of that license. Just want to make sure I'm capturing the intent.
that's probably what you meant to say, right?
That's what you meant to say. That's what I meant to second.
Yeah. Okay. Any further discussion on that change, proposed change? All those in favor signify by saying aye.
Aye.
Are there any opposed? All right, that amendment, proposed amendment has passed. Anything else on page 2? Let's go on to page 3. Any changes, comments, suggestions on page 3? Senator Office.
I guess I'm going to keep rolling then. I would move that we adopt the staff comment at the bottom of page 3, which would strike Romanettes 3 and 4, defining enter or entering or remaining unlawfully. And that's based on the rationale provided by staff.
Second.
Seconded by Representative Lawley. Any conversation about this?
Mr. Chairman?
Co-chair.
Mr. Chairman, I'm not understanding that staff comment eliminates 3 and 4. Are you saying it eliminates paragraph 3 and 4? Or triple I and IV?
Mr. Chairman, yes, that's the intent of the staff comment is the idea that we don't need to explicitly define enter or entering or remaining unlawfully in statute because we have case law and other circumstances where it's already clear that the court interprets the plain language appropriately. So that's the content of what we have in the beginning staff comment. Although the second part of the staff comment is whether or not we want to include a definition of use of deadly force. I didn't include that at this time.
And it's my understanding that TerraPower supports this change as well.
It's my understanding, yeah.
Yes. Any other comments? All those in favor of this proposed amendment signify by saying aye.
Aye.
Any opposed signify by saying nay or no. All right, that proposed amendment has passed. On the bottom of page 3 and top of page 4. Now on to page 4. Any other changes or comments, discussion on page 4?
Mr. Chairman,
Representative Lawley, please.
thank you. I would also move to amend according to the recommendation of LSO of, well, never mind. They talk about, well, we already have a definition of deadly force in the statute, so never mind. I withdraw my comment.
Okay. Let's go on to page 5. Proposed amendments. I feel some coming on. Staff comments on page 5? Okay. So no changes on page 5? No discussion?
Mr. Chair, or Mr. Chair, Co-Chairman.
Yes, Representative Lawley.
Thank you, Mr. Co-Chair. I believe the staff did incorporate these changes within the draft. And so and I support that. So I think that's why nobody was proposing an amendment. These words were changed in this current draft to be consistent with the language in Wyoming statute. So I think that's important for the community to see that the staff did go ahead and do that good work. And so just by accepting this draft, we will accept that.
Okay. All right, thank you, Representative Lawley. Let's go on to page 6. Any comments on page 6? Seeing none, page 7. Staff comments on page 7? Yes, Senator Rothfuss.
I'll just note for those watching at home, the recommendation by TerraPower was not to make the suggested staff comment to utilize this language that we introduced, I think, last session through alternative statute. And I agree with their analysis. I think the language that Mr. Fuller created in D and E is better language, actually, than what we used last time. So clarifying why I'm not making a motion, but I think it's important to address it since it was specifically raised as a staff comment.
All right, thank you, Senator. Let's go on to page 8. Any comments or discussion on page 8? Page 9. Any comments on page 9? Page 10. Page 11. Senator Nethercott had some comments on page 11, paragraph C. And she's not in here right now. It's about reasonable attorney fees, court cost compensation, whether that applies to the company or the individual. Any comments about whether we should remove that or keep that or change that? Senator Rothfuss.
So, Mr. Chairman, I think the consideration that Senator Nethercott was raising is that in our existing statute, which 61204 that we see on page 11 is existing statute, not in the legislation. It calls that out, but that isn't called out in this bill. The question was put back to TerraPower whether they wanted something similar, and I think waiting for that answer and amending later based on the answer is appropriate. So taking no action at this time would be my recommendation.
Okay. All right. Any other comments, changes? Senator Rothfuss.
Thanks. Just a quick comment before we vote, Mr. Chairman. I don't think this legislation is done yet. I share some of the same concerns that Senator Nethercott had. I think it's better than it was last time. We just made it a little bit better through some amendments, so it will be better. We recognize we're operating on a relatively short timeline, but I think it's important for us to have a bill from the Minerals Committee going to the legislative session because this is an important issue. So I'm going to support it at this time and hope that we, as a committee, continue to work with stakeholders to continue to make it better, honestly, because I don't think this is done yet, but it's moving in the right direction and it's an important bill.
Thank you, Senator. Any other comments? Okay, we have a bill draft as amended. We will vote whether to sponsor this as a committee, and that will be a roll call vote.
Mr. Chairman?
Yes, Mr.
And
Co-Chair.
one of the amendments is to change all the nuclear generating stations language throughout the bill to just nuclear facility, right?
With conforming language.
With conforming rights? Yeah, okay.
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 Heather, would you call the roll?
Senator Cooper?
Aye.
Senator Jones? Senator Nethercott, excused.
Excused.
Senator Rothfuss? Representative Campbell?
Aye.
Representative Knapp?
Aye.
Representative Larson?
Aye.
Representative Lawley?
Aye.
Representative Riggins? Aye. Representative Schmidt, excused. Representative Tarver?
Aye.
Representative Weber?
Aye.
Co-Chairman Anderson,
Aye.
Chairman Heiner.
Aye. Members of the committee, we have a sponsored bill.
Probably start in the House, huh?
Congratulations. Okay, thank you for all that have supported us in this. We'll now move on to the aeronautics report, Wyoming Aeronautics report. Look at that, we're almost on time.
Yeah, you're doing good.
Mr. Director Westby?
They're fleeing like rats off a sheep, aren't they?
You're losing your audience, Director.
What do you do, Westby?
Mr. Chairman, that's not new for me, so.
Is this when you start karaoke, this is what happens?
Yes, yes. Well, Mr. Chairman, Mr. Co-Chairman, Committee, thank you for the opportunity. Darren Westby, I'm the Director of Wyoming Department of Transportation. Happy to be here. With me, I have our newly minted, relatively new, Aeronautics Administrator, Sean Burke, and we have our Policy and Planning Coordinator for the Aeronautics Division, Mariah Johnson, with us. And then also batting cleanup down there on the end is Devin Brubaker, who's the Rock Springs Airport Manager, as well as Wyoming Airport Coalition President, current President. So, and then I know we have a lot of other airport representatives in the audience as well, if they didn't leave with the nuclear side of the house. But really just, I know we submitted the report early, and it's in the packet. It's out online. I think just quick summary, high level, airport service is going in a great direction, and we plan to continue that focus. We'll be bringing forward in probably this next session some strategy to continue to strengthen their air service in Wyoming, to really tackle the second part of the title of with your committee of the economic development side of the house. And so with that, Mr. Chairman, I'll turn it over to Mr. Burke to introduce himself, and I think Mariah will probably be running through a majority of the presentation.
Mr. Burke.
Thank you, Mr. Chairman. It's a pleasure to be back in front of your committee. I left YDOT about 4 years ago.
Can't hear you.
Oh, sorry. It's a pleasure to be back. I left YDOT about 4 years ago and did a tour at Denver International Airport and later did some consulting work. So it's, but I'd never left Wyoming. I mean, it's a place that we always call home. So I'm very grateful to be back here. On the air service front, yeah, as Darren, Director Westby said, we're making a lot of progress in terms of restoring and enhancing commercial air service within the state. And we've carried a lot of momentum through COVID, and revenue potential is continuing to grow. The airlines are starting to realize that as well. So we're in a much better position than we were even 5-6 years ago. So with that, I'll be pretty brief and just drop in a couple comments as we kind of move through the presentation, but I'll hand it over to Mariah Johnson, who's our Air Service Development Program Manager, and she will go through the presentation. Mr. Chairman.
Ms. Johnson, welcome, and please proceed.
Thank you, Mr. Chairman. So to start with, we will be providing a full report to the committee about air service over the last year. You'll see that towards the end of September, but this is really just an overview of what we've seen over the last year in the state and kind of where the numbers stand now. On slide number 2, you'll notice our state passenger total levels through calendar year 2024. And as you can see, 2024 was yet again another record year for passengers in the state of Wyoming. We've been seeing an upward tick in our passenger traffic over the last several years, and the last few years have been phenomenal, and we keep seeing that number grow and grow. And then if you look on slide 3, we broke that down for calendar year 2024 by each individual airport, and all of our airports in Wyoming saw passenger growth. We went ahead and showed where they were in the last 25 years in terms of the amount of growth, and you can see that where they were in terms of their levels of passengers, and we had several that it was their #1 year for passengers in the past 25 years. So we were pretty impressed with what we saw in 2024, and honestly, you know, in 2023, we thought that we were seeing some of the greatest numbers, so it's been nice to see things are just getting better and better.
Ms. Johnson, am I missing Jackson on here?
So actually, if you go to slide number 4, we put Jackson on a separate slide. They do have a lot more passenger traffic than the rest of our airlines, or the rest of our airports. So we like to break Jackson out separately so that you can really get a feel for Jackson by itself as well as the other airlines. But Jackson last year in 2024 did see its top year of passengers. And a couple other things to note is that every Wyoming airport saw increases in 2024 over 2023, and overall, our passenger growth across the state was up 11% over 2023. So that was a pretty significant increase when 2023 was such a high year to begin with. On slide 5, we looked at the revenue at all of our Wyoming airports, excluding Jackson, since 2014. And what we really wanted to kind of show here is the revenue growth that we have seen, especially since 2019, at the airports that participate in our capacity purchase agreement, which are Gillette, Riverton, Rock Springs, and Sheridan. You can see how those airports have really taken off in terms of revenue. And the reason that this is so important is that this is what the airlines are going to be looking at when they are determining if a market is viable without any type of economic support. So the fact that we are seeing that kind of revenue growth is telling us that these markets are growing and they are strong, and that they probably will start gaining some attention by the airlines pretty quickly for what they're doing in the short amount of time that they've done it in. On slide 6, we take a look at one of the 2 programs that we run to help support air service within the state. It's the Air Service Enhancement Program. This program has been in place since 2004, and since that time, every commercial service airport in the state has received some level of funding from the program. During this last fiscal year, we had 3 grants at 2 of our airports, Cheyenne and then 2 in Jackson, and we just kind of wanted to break down what the numbers looked like, how much was spent, how many passengers we saw through, and what the cost per passenger was. And then on slide number 7, we look at the other program, which is the capacity purchase agreement, and that breaks down some of the same metrics for the 4 airports that participate in that. On slide number 8, we wanted to look at the first 6 months of 2025 versus 2024. So you'll see your year-over-year passenger growth, and you can see that we're seeing some really, really strong numbers through the first 6 months of the year. Riverton, for the first time ever, hit 10,000 enplanements in May, and that 10,000 enplanement mark is really important, as that's the level that we have to hit in order for these airports to be eligible for $1.3 million in federal entitlement, which they can use for infrastructure, things like that. So it's critical that these airports are hitting that 10,000 mark, and Riverton did it in May for the first time ever. And then another one that I wanted to point out is that Casper saw its highest June enplanements that it has seen since 1987 this year. So we are just seeing 2025 looking like it's going to be a year that's even stronger than 2024 was. On slide 9, we just wanted to talk through some of the trends that we've been seeing across the state. As I've said multiple times, our employments have increased and they're outperforming national averages. At the 4 CPA markets in 2024 grew 21% over 2023, which is 5 times the national average. And these markets are continuing to mature, and we see that with a little more time, they are going to mature to the point where they can exit this program. With that substantial growth we've seen in our passenger traffic, we are continuing to see the impacts of the increased labor costs that the airline industry as a whole is seeing. Our block hour rates for the 4 CPA markets in 2024 were on average 25% higher than they were in 2023. And while our costs have increased, we have not lost air service in any of our communities across the state, which is something that a lot of communities across the country cannot say at this point.
Mr. Chairman, if I can jump in here for a second. I think the map on slide 10 is pretty telling of the number of communities across the country that have felt the impacts of this pilot shortage that we've been experiencing since 2013. I've worked with a couple of these communities personally in my private sector tour of these are communities that are also trying to restore air service to their communities. So in effect, we are competing for limited air service resources with dozens and dozens of other communities across the country. And to a certain extent, it's a lot easier for an airline to say, hey, I already serve one market. I can add a new hub to that market onto it because I already know how that market performs. We don't have that luxury. For the most part, we're still kind of restoring and reaching revenue and passenger maturity within our communities. So it's a competitive landscape out there. For example, in Grand Junction, they've since restored their Delta service to Salt Lake to the tune of $1.5 million. That's just an example of something regionally that's also occurring in this, that we are competing nationally for these resources.
Senator Ruffus.
Thanks, Mr. Chairman. I have a question getting back a little bit to the capacity purchase agreement. Sorry to run backwards, but you just triggered a question. We put that program in place quite a few years ago now, and it looks like we're seeing substantial improvement. I'm kind of looking at Gillette, where the state cost per passenger is significantly down relative to Rock Springs and Riverton. Are we expecting to see through growth in Riverton and Rock Springs, those figures coming down as well? Is that our expectation based on prior data from Gillette? And honestly, Sheridan seems to be doing quite well. And I know that they've only had their service online for a short time. So what do you kind of expect based on projections from this data that we see for the capacity purchase agreement?
Mr. Burke.
Thank you, Mr. Chairman. Senator Rothfuss. Yeah, essentially that's the case. Part of the cost per enplanement is kind of escalated because our block hour rates have increased alongside it. In the case of Gillette, the good news is they'll be exiting the capacity purchase agreement program here by the end of the year. So it's there. We've all kind of modeled it after Gillette of yes, we can restore, we can reach a level of revenue maturity that's going to happen in some of these communities, as well as passenger stimulation that occurs with it too. Part of Rock Springs and Riverton was getting the second flight restored. That's why Riverton and Rock Springs have increased so much higher in the last 6 months, is restoring the second flight. That'll reduce that per passenger cost to the state.
Ms. Johnson, please proceed.
Thank you, Mr. Chairman. So on slide 11, another challenge that we know we are facing as a state and that we're trying to make sure that all of our markets are prepared for is the shift away from the use of small aircrafts. Due to the economics in the airline industry, there's been a shift away from the small aircraft to the larger aircraft because it makes more sense and is more viable for the airlines. The 50-seat or smaller aircrafts usage is down from 45% in calendar year 2005 to 10% in calendar year 2025, and that's across the United States. But the 50-seat or smaller aircrafts make up 54% of Wyoming's flights and 95% of non-Jackson flights. So it's critical to us that we make sure that these markets are ready for and prepared for bigger aircraft when those come online, because we know that those 50-seat aircraft are not going to be able to be used forever. They've been around for a lot of years, and they're getting near the end of their life cycle, and so something's going to have to happen because there's not a new 50-seat aircraft coming into the market. So we're trying to make sure that our markets are prepared and ready for those larger aircraft. And then on slide 12, just to kind of talk about the capacity purchase agreement and what we see going into the future, we signed the last 4-year term of the capacity purchase agreement this spring, and it went into effect beginning July 1. The intent of this program has always been for the communities to mature enough and to support the service enough that they can exit the program. And we, as Mr. Burke mentioned, we're excited that Gillette has hit that point, and beginning in January of 2021, United will be taking over the Gillette market, and it will no longer need the support from the capacity purchase agreement. That being said, we do anticipate that the funding that we have available for the capacity purchase agreement will be exhausted by the end of fiscal year 2026.
And Ms. Johnson, why did we need to add Cheyenne to the program?
Yes, Mr. Chairman, we added Cheyenne to the program because the way that their air service runs is almost identical to what we were seeing with the capacity purchase agreement. And contractually, we have some benefits in the capacity purchase agreement that Cheyenne was not seeing in their agreement on their own. So we felt that those benefits, which are some economic things that, economic tools that we have to help with performance, would be beneficial to Cheyenne, to the taxpayers, because there would be some potential cost savings by having Cheyenne rolled in with the capacity purchase agreement versus just on their own agreement.
So are we increasing the flight number to Cheyenne, or is staying the same, or any changes there?
Right now, Cheyenne is going to be staying the same number of flights, that type of thing. We are always looking at the potential for additional flights, but with that comes additional cost. So we're trying to balance how we make that work and with the funding that we have available, and make sure that we are doing the most we can with those funds.
Senator Ruffus, please.
Thank you. Are there any communities looking to expand? So moving forward, is there any community on the horizon that is trying to either get back their air service or participate in the capacity purchase agreement, or is there nothing else on the horizon?
Yes, Mr. Chairman, Senator Rothfuss, I believe at this point, we have all of the communities participating in the capacity purchase agreement that would want to. I think more what we're seeing is communities looking to utilize the ASEP to bring in additional service, looking at, maybe additional routes, a new airline, that type of thing.
Any other questions? Committee, questions? Devin, I guess it's up to you.
All right, Mr. Chairman, thank you very much, and thank you to the director for the introduction and the continued partnership that we have with WYDOT.
Devin, would you introduce yourself, please?
Yes, Mr. Chairman.
You, but for the record.
My name is Devin Brubaker. I'm the airport director for the Southwest Wyoming Regional Airport in Rock Springs and the current president of the Wyoming Airports Coalition. Thank you for the reminder, Mr. Chairman. Today I'm also joined by representatives from the Northeast Wyoming Regional Airport up in Campbell County, as well as the Jackson Hole Airport up in Teton County, unless any others have entered since we stepped up here. I'm sure there's others on Zoom land as well. This afternoon, Mr. Chairman, I'm here, number one, to thank you, the legislature, for the vision, the leadership when it comes to air service development. We lead the country in innovation when it comes to air service development programs, and that's what allows us to keep our air service in our communities. As our friends to my left here spoke, the number of communities that lost service across the country during the pandemic, every one of those that is listed, nearly every one of those that's listed, is larger than our communities here in Wyoming, yet we were able to keep our service thanks to the innovative programs that have been established by the legislature back in 2004 and then again in 2018. So thank you very much for that. Unlike the federally subsidized programs like the Essential Air Service Program, our programs rely on a different structure focused on a contract for services. That contract for services provides financial credits to the state and the local communities for both financial and operational performance. That was hinted in the answer to your question, Mr. Chairman, about Cheyenne, of there's a better contract language in the CPA program that allows for those incentives, if you will. These service contracts are more conservative air service development programs in the industry, are the most conservative air service development programs in the industry, thanks to those terms and conditions. Those key terms make our state programs far more cost-effective for taxpayers than the federal program. The success of these programs is not only measured with stories like we just heard about what's happening in Campbell County with United taking that market on at risk come January 1st, but also with economic activity created and supported by commercial air service across the state. Based on the data in a 2020 study, every dollar that's invested in these air service programs in Wyoming returned $18.89 of total economic value to the state. When eliminating multipliers and focusing strictly on direct output and direct economic impact, that drops to $12.36. And so still robust. If anybody came to you and said, invest $1 and I'll give you $12.36 back with direct return without multipliers, that's pretty impressive. And Mr. Chairman, as committee members, many of you are aware, Wyoming's 40 public use airports support far more than just commercial air service. However, thanks to commercial aviation in the state, well over $13.5 million of user fee-based federal funding each year is invested in critical infrastructure at our airports. Ms. Johnson spoke about that, the threshold of 10,000 employments, unlocking $1.3 million of investment in our airports. Without that commercial air service, we would not have those funds to invest in the infrastructure necessary to support other key components of aviation like aerial firefighting, air ambulance, flying doctors, aerial applicators, aerial range management, aerial wildlife management, and air cargo. Without that investment, those operations would be severely hampered or not even possible at many of our airports. Additionally, these investments provide the critical infrastructure to support over 150 airport-based aviation-related businesses, employing over 2,000 workers across Wyoming. The impact is felt well beyond those airport-based businesses, with our extractive agricultural, tourism, and advanced manufacturing industries relying on these services to connect to customers, vendors, and to attract workforce. Mr. Chairman, I know time is tight and you have another presentation after us, so I'll leave you with the following statement. In our industry, this is a common saying, and it really does relate to Wyoming. A mile of highway can take you a mile, while a mile of runway can take you anywhere in the world. With 246 lane miles of runway pavement at Wyoming's commercial service airports, our airports can truly connect Wyoming to the global economy. And Mr. Chairman, I do have Todd Chatfield, Mr. Todd Chatfield, the Executive Director from the Northeast Wyoming Regional Airport, who we've talked about today, and he's willing to come up and share about the success that they've seen with the CPA program and how it has provided that runway length necessary for them to mature and grow off of it that we're all striving to do as communities. So if it is your pleasure, Mr. Chairman, would welcome Todd up here to share a few brief words as well. And I'm happy to stand for any questions.
We'll have to dismiss some people to make room. Mr. Brubaugh. I like that comment about the mile of runway.
Yeah, that's good.
We have a question over here from someone that you may know, Kevin.
He looks a little familiar, Mr. Chairman.
Thank you, Mr. Chairman, and thank you, Mr. Brubaker, for attending the meeting and giving us an update. I had a question about your return on investment figure. Does that include Jackson's numbers?
Mr. Chairman, a good question, astute question. It does include Jackson's numbers. However, if you remove Jackson from those numbers, they are still very worthy of recognition, including induced and direct impacts. It's $8.75 per dollar invested. If you just do direct impacts only, it's $5.65 per dollar invested.
Jones. Looks like you have questions seated here in the committee with members of your own community.
Mr. Chairman, Mr. Brubaker, I just had a quick question, just in reference to Sweetwater County getting a new upgrade on our terminal. How much do you think that will affect the people going in and out of Rock Springs for businesses and things like that in our area? Do you expect it to bump things up? I know people like to go in and out of nicer things, so how much difference does that make?
Mr. Brubaker.
Mr. Chairman, Senator, excellent question. For the committee that's not aware, we are 29 days away from opening a brand new airline terminal in Sweetwater County. We will be opening it up to our first flight on August 27th with a ribbon cutting coming shortly after that. Anytime you build a new terminal, it opens up new doors and new opportunities. Folks, the community we've all heard about consumer confidence and the idea that when you have a facility that has the modern amenities that you see at larger airports, it does build that consumer confidence. But what's more important is the fact that our former terminal specific to Sweetwater County could not support aircraft that are larger than 50 seats. It was built in a pre-9/11 area where we had 19-seat aircraft and we didn't have a security checkpoint smack in the middle of the building. With what we heard from WYDOT about the change to larger aircraft in our industry, our airports, our terminals across the state absolutely need to be improved. We are one of the last ones in the state that needed that. Riverton is next up, but those investments are going to allow us to be able to support those larger aircraft and unlock the door to talking to additional airlines. In our community, we're having active discussions with multiple air carriers about additional service to our community to supplement what we already have. So I hope that answers the question, Senator. It opens a lot of doors for us, and it's going to make a big difference come here in 29 days. So,
any other questions? Co-chair.
Mr. Chairman, are your runways long enough for the larger airplanes also?
Mr. Brubaker.
Mr. Chairman, Mr. Co-Chairman, yes, I'm sad to announce or say that we have the second longest runway in Wyoming, only behind your hometown airport. Our runway is 10,001 foot long, so we just missed the boat. It's not too cost effective to play that game with Glenn or Mr. Januska to try to beat him on a longer runway, but our runway is more than capable of supporting any aircraft that we could conceivably think that would fly into Sweetwater County.
Mr. Brubaker, in the handout that you gave us for the business travel air service, how do you differentiate between tourism versus healthcare? When these people board, how do you know what category they fit into?
Mr. Chairman, excellent question. So a lot of the data that you see on this handout is based on the 2020 economic impact study that was done. We're in the middle of doing a new one in 2025. And as part of that, if you walked into our terminals today across the state, every terminal has QR codes all over the place. It has paper surveys all over the place, has business cards with QR codes on them for our passengers to fill them out and answer surveys about what business, what's the name of their business,
Maybe we need to slow.
We got senators throwing things at me now. This is awesome. Sorry, Mr. Chairman. But those surveys ask questions like the name of their business, the type of business they do, the amount of money that they spend when they visit our community, if they're a resident, what type of business, and ask a whole host of questions. And so we collect thousands and thousands, tens of thousands of surveys across the year. We did that in 2020. We're doing it again in 2025 at every one of our airports. And so that information then is aggregated to collect data just like this that you see here.
All right, thank you. Okay.
Thank you, Mr. Brubaker, Chairman, members of the committee. My name is Todd Chatfield, Airport Director in Gillette, Wyoming. The CPA has been a critical part of our airport success since COVID. Gillette wouldn't have air service if it wasn't for this program. In January, as you've been told, the United Airlines will be taking over Gillette at risk. This means that our share of the CPA will go to help other airports move off the agreement with SkyWest. In order for the other airports to be successful, this program needs to continue. When the Wyoming Legislative Commercial Air Service Improvement Act of 2018 was created, it established the framework to keep air service in the state, and it's done exactly that. Gillette is a testament of the program's success, and it has done exactly what it was set out to do. And I'd like to thank the legislature back in 2018 and now to recognize that, we needed some help and gave us some help. And I think you guys can see by our success that it has worked. So thank you, and I stand for questions.
Thank you, Mr. Sheffield. Co-Chair Anderson.
Mr. Chairman, I'm assuming that United will just service Denver. Do you have anybody else servicing other places that you used to have?
Chairman, Co-Chairman Anderson, no, we go directly to Denver.
Any other questions? Seeing none, thank you very much for your time and your testimony.
Thank you.
We will now open it up for public comments. Governor's office, first dibs. Any? All right. Just checking to make sure you're still here. All right. Anyone like to provide any public testimony? Mr. McKay.
Mr. Chairman, thank you very much. Rennie McKay, President of the Wyoming Business Alliance. And as I mentioned earlier, we have members from every industry in every corner of the state. And as we advocate for that environment that helps businesses prosper, air service is definitely one of them. And I'll just highlight another factor is that when we're talking about these programs to support air service, the private sector does often step up. And so we do have a good public-private partnership where Business Alliance members and other businesses around the state put in additional dollars to make sure that there's air service there because they see the value in it. And there's a couple studies that I would just point to. If you all are looking for information about how valuable this is, and I really appreciate that even though this isn't necessarily something that comes directly to you, the economic impact and the business impact of air service is so important to this committee. But as you look at what we've seen across the country, there was a study that showed that businesses and communities with more frequent and reliable air service experience faster employment and GDP growth. And then MIT also did a study that found that reductions in air service led to a measurable decrease in local economic output, especially in communities with a population of under 500,000. So when you are looking to try to support Wyoming businesses and communities, this is certainly a means to do it. So thank you for spending a little time on this topic, and I hope you all see something in the budget this year that supports this program so we can get this continued growth we've seen that also accompanies our growth in jobs in Wyoming. So we're making progress. People are hiring a lot of people in Wyoming right now, and we can keep going.
Thank you, Mr. McKay. Any questions? Thank you for your testimony.
Thank you, Mr. Chairman.
Any other public testimony? The table is open. Any public testimony? Anyone online? With that, we'll close public testimony. Committee, any comments, any directives? Anything you'd like to say? All right, thank you. Thank you for your time and your talents. Our last topic for the day is carbon geocapture. That's a big word. Well, we're going to find out what it means.
Oh, you're too nice to him. Too nice to him.
Mr. Jordan, welcome. Jordan Pope. John Pope, I'm sorry.
It's that kind of day, isn't it, Mr. Chairman?
There's been a
Mr. Chairman.
lot of people today.
All good.
At my age, I missed my nap.
Me too. Mr. Chairman, committee members, thanks for having us here today. I'm here to tell you about a opportunity that has been.
Mr. Pope, could you pull that a little closer?
Yeah, you bet. When I'm tired, I talk quietly. So I'm here to tell you about an opportunity that we've been developing in Laramie for the last 25 years that has some relevance to the topics of power generation and carbon intensity related to that, as well as natural gas production. So my name's John Pope. I'm CEO of Carbon GeoCapture. On slide 2, it summarizes part of the relevance from a carbon standpoint. The statement that we make is that economical CCUS is now commercially available. And the basis of that is the work that we've done on the shoulders of many others to take advantage of the fact that unminable coal seams scrub dilute flue gases from power plants and other industrial plants. And the reason that that's important is because scrubbing those flue gases is the most expensive part of CCS or CCUS. At the end of the day, because the coal helps us and makes this process less expensive, the federal tax credits that exist under 45Q and that have been recently boosted enable positive project economics for people that develop projects using this coal-assisted CCS. And what that means is that you can produce power for folks at the same cost or lower cost when it's low carbon, if the low carbon intensity, if you use the coal to help. And so there's some ramifications of this that I'm going to walk you through here today, Mr. Chairman. And that includes, number one, that this helps our coal-fired power plants in Wyoming and our natural gas-fired power plants become more resilient to what might happen next in terms of the whipsaw of policy changes. Right now, we do have lots of carrots that are helping us take these steps, but the sticks will be coming back. I don't think anybody doubts that. Also, this offers a market-side opportunity to our coal-fired power plants and our natural gas-fired power plants to participate in providing increased power to data centers, but also, as Mr. Detai talked about earlier, to all the other increased users of electricity and power that we have in our market. On slide 3, this really describes why the coal helps us and how the coal helps us to make this possible. Again, scrubbing the flue gas of a power plant, for example, to produce a concentrated stream of CO2 that you can put into the ground or that you can use for EOR is the most expensive part of that CCS or CCUS process. And you can see in this chart on the left side in the gray, that's the cost structure of what we would call conventional CCS. And most of the cost goes into scrubbing. When you heard earlier about an amine plant costing so much money on the Neil Simpson complex coal-fired unit, for example, that cost was driven by the scrubbing. The amine does the scrubbing. That's the connection there. And so if we let the coal do the scrubbing for us instead, it reduces that cost significantly. In some cases, we don't have to scrub at all. In power plant cases, we will still scrub to some extent. But still, overall, it drops the cost of the CCS or CCUS to the point where it is economical to do under existing federal tax incentives combined with, and in fact, maybe even with voluntary credits alone. And just to make it clear, coal is considered to be a viable carbon sink by the industry, by the scientific community, and by the federal government. Unminable coal seams are included explicitly in the 45Q language. And so this is not a new sink. This is a well-established one. On the next slide, that really highlights for...
Mr. Pope,
Yeah, Mr. Chairman.
is that little graph you have on the side, is that pretty accurate numbers? So with this coal-assisted CCUS, you actually are able to make money just off 45Q.
Mr. Chairman, yes.
Thank you.
Yes.
Mr. Chairman?
Yes.
Mr. Chairman, so am I understanding you to say you're taking all the flue gas and putting it to the coal seam, and that coal seam is doing your scrubbing?
In the case where we don't have to scrub at all, that's the answer is yes, Mr. Chairman. In the case where we need to do a little bit of scrubbing, because it's more economical to do a little bit of scrubbing than to compress all of the flue gas downhole, in those cases, the scrubbers usually only have a 90%, 93% capture rate. So there's a small part of the flue gas that we don't take in those cases. So on slide 4, this gives you an illustration of why this approach is important in our industry and for the power generation cases. And so, yes, these numbers are real. These numbers actually are the result of millions of dollars of study by us and others. And so these are not spreadsheet outputs. These are pre-feasibility and feasibility study outputs. And what you can see, again, is that the 45Q tax credit is sufficient to support CCS and CCUS in the natural gas-fired case and in the coal-fired case. And that's even before you consider the voluntary credit value as well. And one of the reasons why CCUS has been struggling, in fact, the main reason why CCS and even CCUS has been struggling is because in the blue bars, you can see that it's just not the case. That the expense of that approach is just too high. And so only in a very few cases, we estimate less than 20% of the point source cases in the US can conventional CCS, CCUS be viable. If you look at slide 5, then generally we're developing a large number of projects across the U.S. We have about 6 projects at the planning stage, which is pre-construction. We have about 11 at the feasibility stage and more than 70 at the scoping stage. And they range across a number of industries, as you can see here, from trona processing to power to natural gas processing to cement.
Representative Campbell.
Thank you, Mr. Chairman, and thank you for being here today, John. I'm looking at this map. You're a Wyoming company, and you're in as a Wyoming company, how many different states are you operating in right now?
Mr. Chairman, I believe the last time I checked, Representative, it was 17.
17. Thank you very kindly, sir.
National.
Mr. Chairman, correct. We have a project in South Australia, and we have several that are early stage in Turkey and in Europe. And while, Mr. Chairman, while generally, these, I think it's important for the committee to be aware that this approach exists. There's some Wyoming impacts that I think are really important for the committee to be aware of, and they start on slide 7. So on slide 7, this just highlights, not with our numbers, but third-party numbers that are credible, that there's about 360 trillion cubic feet of natural gas stranded in Wyoming coal right now. Despite all of the effort that we've all gone through in the past, we've only produced about 7 TCF of coal bed methane so far in this state. If we produce that 360 TCF, and turned it into power, for example, using a natural gas-fired turbine, that would make about 10,000 gigawatts of power that we could use for data centers or whatever else we wanted. And you can also see on the sheet the mineral payments and the royalty payments that this asset represents. So that's something that we think is not controversial or challenged by anybody. This is fact. On slide 8, this also shows those same coal sinks and the potential that they hold for storing carbon. Because as I'm sure that you're aware, Mr. Chairman and committee, that right now in the United States, you can be paid to store carbon through 45Q tax credits. And so this is, there's 213 gigatons of CO2 capacity in Wyoming is what we estimate. There's only about 500 gigatons of CO2 capacity in the entire US, continental US, in our estimates. These are our estimates now. So Wyoming has, especially the Green River Basin, Wyoming has, in our view, the most attractive coal sinks in the country. And if you look at slide 9, then this is a proper map of coal in Wyoming done by the WGS. And these arrows show the projects that we have that are active in Wyoming. We have, I believe, 11 projects active in Wyoming. More importantly, though, more than half of our advanced projects are in Wyoming. Partially that's because we live in Laramie, mainly, and we started here. Partially that's because the Oil and Gas Commission in Wyoming has been amenable to working with us on this. And partially it's because Wyoming has, in our view, the only complete legislative jurisdiction in the world for CCS, CCUS. And so right now, Wyoming is a very attractive place to do this. That's attractive for us as a company, that's attractive for our project partners, and we believe it's also attractive for Wyoming.
Yes. Oh,
Representative Campbell.
Thank you, Mr. Chairman, and thank you, John. Is that because we have supremacy? Is that what gives us, that makes us so attractive for this? Could you describe that a little? Thank
Sure,
you.
Mr. Chairman, Representative, the answer in this particular case is no. Now, these projects proceed under Class 2 permits, and the reason why is because we put CO2 into the ground and we thereby produce natural gas. People have been doing that for decades, but it was not economic. Now that we're being paid for putting the CO2 away as well as produce the natural gas, now it's economic. And so we use Class 2 permits, which most states in the United States have primacy over Class 2.
Co-Chair Anderson.
Mr. Chairman, I'm back on 7. Sorry, I'm a little slow, John.
Yeah.
But it says mineral owners are revenues of 38 billion, state royalties and taxes are 65 billion. I didn't realize that we would get more taxes and royalties than the owners actually got. Is that correct?
Mr. Chairman, the mineral owners in this case are fee owners. These are private owners. And so the state also earns other fees when a project proceeds on state and federal lands.
Thank you.
Yeah, thank you for the question, Mr. Chairman. So if we go to slide 11 briefly, I won't take you through the background deeply, but I did want to highlight that, again, the work that we're doing is based on research and based on commercial work that's happened around the world for more than 100 years. And it is a very deep amount of work product that's occurred. There's been more than 400,000 tons of CO2 put into coal seams in order to produce natural gas previously. Now, they did it a little bit different way than we do. We believe that we do it in a way that is safer for the coal seam and for the aquifers around it. But again, this is something that we took and modernized, and we've been deploying it now for the last 4 years quietly. The last few months is the first time we've really talked to people about what we're doing. Slide 12 would help me explain to you exactly how it works. All coal has methane in it, natural gas. Mr. Chairman, all coal has water in it. What we do is lift water from the coal seam. We drop it into another well in that coal seam, and it gravity feeds. While it's happening, we bubble CO2 or the flue gas, all of the flue gas into the water and dissolve it. The water carries that dissolved flue gas across the coal takes it out, the water passes through, we lift the water, we do it again. While that's happening, natural gas that's in the coal seam is pushed in front, and if we allow it, it'll be produced at the water production well. And so what this means is that this is a closed loop. There's no net water production or use of any material amount. What it also means is that this is a water discharge-free way of producing coal bed methane. And so this is a way that we can actually produce this natural gas without having to solve the water discharge issues that we struggled with so much as a state before. And so this is, and then the coal itself has been holding the methane and natural CO2 for thousands of years. And so this is a secure sink that will hold this CO2 that we put in it for a long time, as long as we pay attention to how we do it. So, Mr. Chairman, on slide 13, it highlights, yes.
Mr. Chairman, so you're producing water and you're bringing the methane up with the water. Then what are you doing with the water? Are you injecting it right back in?
Yeah, actually, Mr. Chairman, we put the water back into the well and we use it to carry the CO2 back in. So while we pull the water up, we put it back in, and as a result, the pressure on the coal seam does not change significantly. And slide 13 really highlights the difference between this and the conventional CCS approach. In a conventional CCS approach, we purify the CO2, we blow up a big balloon of high pressure gas deep in the ground, 10,000 feet many times. We have to make sure that the rock above it is going to hold that balloon in place, because if the rock won't hold it, then that gas can escape potentially, right? And you know, in the coal-assisted case, instead we go to coal seams that are only maybe 1,000 to 3,000 feet deep. Excuse me, Mr. Chairman, and we put it into the coal, which is a nanoporous sponge. And we do it at a pressure that is below the existing water pressure on that coal seam. So this is an under-pressurized sink. And in every way that you can imagine it, that's a much safer and more permanent approach to carbon management. So, and of course, as we've already said, it doesn't require pure CO2. Slide 14 shows what that you know, these cartoons look like whenever you start to map out a full commercial project. Where you take the flue gas from an industrial plant and you dissolve it in water that you've taken from a coal seam, and you do that in a closed loop. And then you produce yellow natural gas in some cases if you choose. Again, we've piloted this in Wyoming. It's the only place in the world that this has been piloted, by the way. But we piloted this twice in Wyoming, one about an hour north of here, in the middle of the PRB, and another one, we're in the middle of a pilot on the Black Hills Energy Neil Simpson complex. We've drilled 3 wells just east of the Wygen 3 unit, and those are ones that we're actively working to get CO2 into now. We have being able to tell people what we're doing and show them what we're doing and measure what we're doing and prove that what we're doing is true has become a really important thing in the carbon credit industry. And so we have an extensive monitoring, validation, and reporting process that we've developed based in Laramie, based on sensors and technologies that we've developed in Laramie. We have patents that are issued on all of this stuff. One of the things that is important is to realize that this is not research. This is not early, this is not a technical readiness level of 5. In fact, Black and Veatch spent a year with us last year looking at the technical readiness level of every part of our process, and slide 15 shows the results of that. And what you'll see.
Pope?
Yes.
What is a Raman measurement?
A Raman, Mr. Chairman, a Raman measurement is where you shine light on a material and it bounces off, and you look at the change in color of the light and it tells you the chemical bond that absorbed some of it. And so by looking at the change in color of the light, you can know what chemical bond is in the material. By looking at how many photons changed in that color, you can know the concentration of those of that material. And so if you want to see it in action, there's one out in the foyer. There's a Raman spectrometer out there that we're running water with CO2 in it through it, so you can actually see that spectrometer, which, by the way, is unique in the world, developed in Laramie, patented extensively by Well-Dog, and eventually used by this company a bunch. But you can see this whole process in action out in the foyer. In fact, if you'd like to put CO2 into coal, and then watch and then release the pressure, which wouldn't happen in Mother Nature unless we dewatered the coal seam. But if you'd like to see that happen, you can check out the demo unit that we brought up from Laramie for this. But Mr. Chairman, slide 15 though shows that again that this process in all aspects is commercially ready. Technical readiness level 8 means that it's ready for commercial use. Technical readiness level 9 means that it's happening at scale. The reality is that there's nothing happening at scale in CCS, CCUS. None of the projects work financially. None of the projects are proceeding for the most part. with a few exceptions. Slide 16, we're almost finished. Thanks for your patience at the end of the day. Slide 16, Mr. Chairman, just touches on a few other things here, which again, this process is designed from the get-go to protect the water resources. And so there's no net water use or production. We're not introducing foreign fluids to these coal seams. We're using the fluid that's in the coal seam. And that for us is really important. The Class 2 permitting process that we follow requires that we evaluate and make the case that the process protects underground sources of drinking water that might be nearby, might be shallower. We look at migratory pathway potentials through other wells, all of these pieces. That's required for us to be able to do any of this work. And of course, we continuously monitor these projects. And then the last thing is just to highlight that while we get to use this Section 45Q to subsidize the carbon injection, which all of a sudden makes it possible for us to do enhanced coal bed methane in a way that's economical, the process itself is heavily carbon negative. The coal will hold 10 times more CO2 than it will hold natural gas in any case. And what that means is that if you're a power producer and you know that you're going to have customers that demand low carbon intensity power for you, this provides that as well. And so it's a win-win-win.
Mr. Chairman?
Mr. Co-Chair.
Mr. Pope, I'm wondering how relevant or how significant your natural gas production is. If you had input from the plant of X number of million cubic foot and it goes through your process here, how much natural gas are you getting out?
Mr. Pope.
Mr. Chairman, it's an excellent question. And while we wish that the natural gas that would come out would be enough to power the plant that would produce the power that we then take the CO2 from, it's not sufficient. Most coals historically have lost most of their natural gas, and what's left is just what was trapped by the water pressure. So typically, again, whenever we design our projects, we typically expect to put 10 times more CO2 in the ground from a power plant or industrial plant than the natural gas we get out.
Mr. Pope, what coal bed methane producing wells, they produce methane and some CO2, and the CO2 had to be scrubbed out of the methane. So with this process, you're liberating some natural gas, methane. There will be some residual CO2 in that methane. Is that correct, Mr. Pope?
Mr. Chairman, it depends on the area. It's true that some coal bed methane is associated with CO2 production, especially later in the field production life cycles. It's not always true. A lot of coal bed methane production is actually 98% methane. And so it depends. In our projects, we expect that in some cases, we will have to separate the CO2 and the natural gas, which is straightforward, of course, with natural gas processing amine units, but not in every case.
So Mr. Pope, as you inject flue gas from a coal-fired power plant, let's say, into these coal seams, you're liberating some methane, and the CO2 is absorbed, but what about the NOx, the CO, some of these other components? Is that slipped or is that absorbed as well?
So the primary components of most of these flue gases besides CO2 is water and nitrogen and sometimes oxygen. So when we dissolve the flue gas into the water, the nitrogen does not dissolve well, neither does the oxygen. Obviously the water is fine. The SOx and NOx are present, but at very low levels comparably. And so in those cases, the SOx does dissolve pretty well, the NOx does not. And so when you do the water dissolution step, you do separate those gases and you manage the result of that at the wellhead of the injector. And then the other items go into the coal and they're soaked up by the coal. And by using reservoir pressure management, you can choose which ones you let come out of the production well to some extent. But to the extent that you have to clean it up after, then you deal with it. Yeah. But this does offer not just, remember, even for a coal-fired power plant, for example, this does offer an opportunity for 90+% of the flue gas to be put back into the ground where it came from, right? And so from a particulate standpoint, from an air quality permit standpoint, this has relevance for those things as well.
Mr. Chairman?
Yes, Mr. Co-Chair.
Mr. Pope, where would you inject that flue gas? Are you injecting it under the coal seam or directly in the coal seam? Say you have a 300-foot Big George there, where would you put the flue gas?
Mr. Chairman, the way that the process practically works is that first we would circulate fluid that we took from that coal seam. We'd lift it up one well, we'd drop it in another well and let it gravity feed back, and we would just circulate it until it was stable, right? And so while that was happening, in order to maximize the speed at which we could eventually put the CO2 into the coal and the natural gas would come out, we would perforate or otherwise complete the entire interval. And then once that, and so we would circulate the water until it's stable, and then we would dissolve the flue gas in the water as it's going in a dynamic fashion. So the answer to your question is that we strive to use the entire interval.
Thank you.
Any other questions? Questions for Mr. Pope? Representative Riggins, and then we'll come back to Senator Cooper.
Thank you, Mr. Chairman. So would your process, would it qualify for 45Q? But I know you're taking it in, you're injecting it, but you're not getting rid of all of it. You have to keep processing and processing as it collects. At some point, have you accurately measured what you've sequestered and be eligible for any credits?
Mr. Chairman, Representative, yes, the answer is yes. Actually, in fact, on slide 16, that monitoring well in the middle, that's where we would be using one of those Raman spectrometers that's out there. We have ones that go down into the ground. And so we go down and actually measure how much CO2 is in the ground. Now, generally, while we circulate it over and over again, that's not because the coal doesn't take the CO2, all of the CO2 out each time. It's just because we use the water to load the coal up. So when we take the water out, there's nothing in it. We put it back down, put CO2 in it, and continue until the coal is full. But yes, the process from the start is eligible for 45Q, which we've confirmed with the IRS. But
Senator Cooper.
Thank you, Mr. Chairman. Mr. Pope, pretty fascinating program. I'm really intrigued by it. Obviously, you're pretty reliant on 45Q to make this economic. Would you say that our House Bill 200 had any impact on helping develop this or expediting the development of this?
Mr. Chairman, Senator, we don't like to be reliant on any one thing, especially associated with the government, to be frank. But our projects, most of our projects can be economic with just the voluntary carbon credits, even without the 45Q, or with just the 45Q without the voluntary credits. And that's how we like it. We like them to be resilient. To answer your question then, the reason that I'm sitting here is almost certainly because of HB 200, because the projects in Wyoming are led actually by projects that are associated with regulated utility, in particular one regulated utility who was prompted to look at us as a solution because of HB 200. And while we've never received any money from HB 200, that certainly is at least not to my knowledge, that certainly is the impetus for what drove them to be our lead project right now. And I'm here because our lead project, should not be the one telling you about this. We should be.
Bit of a follow-up. Mr. Chairman, thank you. So with the 45Qs, those are for the generator. So they're being paid for sequestering or disposing of their flue gas, if you will, and then they're paying you for doing that from the 45Qs. Do you receive any direct payment from the 45Q, or is it through an operator or through a generator that provides you with the flue gas, or how does that work, please?
Mr. Chairman, Senator, right now in the industry, there's no projects besides maybe a very few in the country that have received 45Q for anything. So just want to be clear that while we have projects that are nearing construction, the entire industry doesn't have projects that are operating fully economically. So that's the first thing. The second thing is that the way that 45Q works is it pays the company that captures the CO2. And so in our case, we set up project vehicles that capture the CO2 and sequester it for each industrial plant, and that's the entity that gets the 45Q. Yeah.
One more.
Chairman, thank you, Mr. Chairman. So along with that, you're probably developing quite a few tax or carbon credits that are marketable too. Is that fair to say, or do you think they're actually there?
Mr. Chairman, Senator, the answer is yes. And as I've mentioned before, having a what's called a high charisma carbon credit that the private market would pay a lot of money for, that's a key step in making sure that our projects could survive without 45Q, for example, or that projects that need both 45Q and voluntary credits can be successful. And so what we've developed is also a process that using a blockchain actually that inventories every step of our process of sequestering, of scrubbing and sequestering the CO2, and generates digital assets that represent that process and that have all the data required for a third party to validate it. And then that is the digital asset that's used to adjust it to as an instrument in a voluntary credit private transaction. Yes, and and I'm answering it that way because I think that the assumption of the question, which is that whole process is really important, is very accurate, which is why we've spent a lot of time and effort on it. Yeah, thank you.
Any follow-up? Representative Larson.
Thank you, Mr. Chairman, and Mr. Pope, thank you for being here. So earlier today, prior to your presentation, we had a discussion around repealing House Bill 200. Does that pose concerns to you that we're even discussing that? Does that harm your ability to move forward if we do end up repealing that in session if someone were to bring it as a personal bill?
Mr. Chairman, Representative, of the projects that are shown in Wyoming on slide, on slide 9, I think there's probably 2, maybe 3 that House Bill 200 would be relevant to. And for those projects, I think House Bill 200 is relevant. Whether those projects, would be able to move forward without House Bill 200, it's not clear to me. I know that I'm not aware that House Bill 200 has contributed to any of those projects yet, but I know that whenever we're dealing with a regulated utility partner, their hands are tied. They have limited options for advancing projects like this to the stage of construction. And these projects, are economically feasible, so they can attract third-party financing, right? So even for like a regulated utility, I don't believe that anybody around the table would expect the ratepayers to pay for construction, but getting the project to the point where it's demonstrated and viable, its viability is demonstrated for the private capital market. That is an important thing that we have to do, and I think that's where House Bill 200 can play a part.
Follow-up?
Thank you, Mr. Chairman. So would it be fair to say it concerns you that if we do remove House Bill 200, regulated utilities will just back off and throw out the idea?
Mr. Chairman, my job is to be concerned about everything. So I can't say that I'm not concerned by it, but I also, we have lots of projects, and also, the regulated utilities that are committed to finding a solution will find a way, I would think, But I do think that having more arrows in their quiver is helpful to them.
Any other questions for Mr. Pope? Seeing none, thank you very much.
Mr. Chairman, thank you. Thank you.
Very informational. Do we have any public comments from the governor's office, maybe? Just giving you an opportunity, recognizing you're here. Any? I will let you know. Any public comments? Public testimony? Going once? Anybody online? Going twice? All right, we'll close public comments. Committee, any directives, any comments about? this or any topic
Mr.
today.
Chairman, I sure like to encourage him any way we can to take flue gas and convert it into methane and CO2. So I'm really, really enthused hearing about this. I hope we can continue to help him any way we can. Thank you.
And if he can convert any of that to gold, it'd be even better, wouldn't it?
Yeah.
Black gold, Texas tea.
Black gold, yeah.
All right. Any comments for the end of the day before we adjourn? Committee? Mr. Co-Chair.
Mr. Co-Chair, be sure and return tomorrow, 8:30 a.m. We're going to have a lot of fun tomorrow. We're going to have so much fun tomorrow, be more fun than you can have with your boots off. That's how much fun it's going to be.
With that, we will adjourn for the day. Thank you
Yeah.
very much. So if there gets to be a lot of people